Yes.
My lord, yesterday is better. I have filed yesterday. It may be allowed to bring at 12 noon because 2 p.m. tender would be open. Right?
Okay.
Hello. Well, I make an item of 2 minutes. So it's fixed, my lord will be kind enough to refer the matter today, my lord.
Huh?
Refer the matter today, my lord.
Who's for the petitioner? Any objection?
No.
So when do we list this?
Immediate after
Vacation.
After vacation.
Right, on the prayer made by Mr. D. Gogoi, Learned Counsel for the Forest Department, which is not objected to by Mr.
BD data.
B.D. Dekha, Learned Counsel for the petitioner, list the matter after vacation.
Public.
I beg to mention item 11.
Yes.
In this case, we are going to file a reply today.
Okay.
So the matter will come after vacation.
Who's for the other side? Mr. Bhattakur, any objection?
There's an interim whatever.
What is the case about?
It's a appointment of LPG
Allotment
distributor.
of
Huh?
Appointment of LPG distributor.
LPG distributor.
next week or after reopening of the
Before my if possible, before vacation.
Before.
I have the record, my
Well, so you have filed the reply. What is there? You know everything.
today and
Today?
next week.
Why not today?
Next week.
Because you have filed the affidavit in reply. You know what's going on. He doesn't mind today also.
So what is happening? The diary is like the artificial progress, right?
Mr. Nair,
Isn't it's like the artificial progress.
okay, right.
No.
Mr.
H.
H. Khetri, Learned Counsel for the petition and submit that affidavit in reply has been filed today. He prays that the matter may be decided in the next week. This is the matter in the next week. Next.
26.
May I please, Your Lordship? I beg to mention item number 1 of this daily list, Lordship.
Item 1.
Yes, Lordship. I have taken consent from the other side, Lordship. Lordship, can you be deeper for today, Lordship? And Lordship, matter may fix on first from
You're for whom?
Industries and Commerce Department.
Who's for the petitioner? Madam, are you going to file affidavit in reply? No, it's a very simple thing. You have taken time to file reply. Are you filing it or not? Right, Miss N. Saikia, Learned Counsel for the petitioner, is granted a further 2 weeks time to file
No,
affidavit.
Lordship, first week of August, Lordship.
I'm granting them. Who are you? Is granted a further 2 weeks time to file affidavit in reply to the affidavit filed by the respondents number 2, 3, and 5. Accordingly, leave this matter after the vacation.
First week of August.
When? First week or give a date. It's 3 weeks. Give 3 weeks. 5th. Next.
Lord, I think 2 there was an interim.
Item 2. Okay, item 2, interim order to continue till the next week. Applied.
May I please, Lordship? Lordship, I beg to mention item number 21, Lordship. Lordship, my senior is not well today, Lordship. Please.
No, just a minute, Mr. Counsel. You are Mr. B.D. Dekha.
Yes.
You're for the petitioner.
The petitioner, the
Oh.
respondent had sorted.
He filed what? He filed affidavit in opposition.
No, Lord, he's just seeking time. The Department of Forest.
Okay, what have I said? In item 2. No. D. Gogoi is number 2 is D. Gogoi.
Yes.
Okay, yes. Okay, yes.
Right.
Yes,
Lordship, I beg to mention item number 21, Lordship.
yes.
Lordship, my senior is not well today, Lordship. He's suffering from kidney problem, Lordship.
Okay, right. Huh?
Item 21 of supplementary listening, Lordship.
Okay, well, BA, commercial quantity, already started.
Similar matter, Lordship. Item number 27, Lordship.
No. So what do you want?
Lordship, I want the adjournment to the Lordship. My senior is not well to the Lordship. That's why.
मतलब he said that item 27 also मतलब same. Yes.
21 and 27 same.
Same. So scan copy came in 27. So matter maybe both the matter maybe take and
Yes.
fix another date. मतलब he is also seeking adjournment.
Why?
Lordship, I will file a,
21.
Lordship, my senior is not well today, Lordship.
So
Please,
when do you want it?
Lordship.
When do you want it to be listed?
Next week, Lordship. Next week, Lordship.
Right, on the prayer for adjournment made on behalf of Mr. N.H. Mazarbuyan, Learned Counsel for the petitioner. In item 21, huh? List the matter next week. Give a date.
Item number 27.
Item 27 also on the prayer of the petitioner, list the matter on so along with bail application number 1709 of 2024.
Hello.
My pleasure, Lordship. Praying for withdrawing a matter, civil bench for matter, my lord. Matters become infractions.
Okay,
So for listing it for withdrawal, my praying.
tomorrow.
Tomorrow.
May I please, Your Lordship? Lordship, I am praying for listing of motion matters, Lordship, identical motion matter, Lordship. Missing Autonomous Council has issued NIT for Lordship. Again, the.
Tomorrow.
Tomorrow, identical matters. Motion.
Thank you, Your Lordship. The Lordship, I would like to mention item for filing, WPC 681824 for Monday, that is 24 of this month, for listing.
Listing, new matter,
Yes,
not
sir.
listed. Okay. It's okay. We'll do that.
Your Worship, we have filed on IA for substitution of legal heir of the diseases petitioner number 4 and 5, WBC number 5748 of 2016. And the main petitioner has been the listed tomorrow before this court. And item number 8, so I pray for listing for tomorrow.
Okay.
Item 24 withdrawal.
May I please, Your Lordship?
Mr.
J. Abbas, Lordship.
J. Abbas, Learned Counsel for the petitioner. Why do you want to withdraw?
It has become infractions, Lordship. If they are.
Learned Counsel for the petitioner submits that the matter has become infractive and accordingly he prays that he may be allowed to withdraw the petition. The prayer of the petition's counsel is allowed. This petition is dismissed as withdrawn.
That's my.
Item 22 for motion.
May I please? Also, in this case, we have changed the order, NIT dated 35/2024, Lordship. Basically on two grounds. Lordship. Clause 10 of the NIT, which is already, Lordship has dealt with the, who is given 3 days additional time to the highest bidder to meet the, to meet his, to submit the requisite documents, Lordship. As well as the second ground is that, Lordship, Rule 47 provides for 45 days. But in this case,
45 days.
45 days. Okay, but in this
Rule,
case,
which rule?
Rule 47 2, Lordship.
47(2).
Yes. Lordship, think of the Assam Concept Financial Rules 2002, Lordship. It's 47 2. Because that such tender notice shall be floated at least 45 days before the last day of.
This is for a what? This is for a market, for a hut.
Yes, Lordship. It's
So are you running the market?
No, Lordship, press NIT, Lordship, they have issued.
So what is wrong? When is the last date?
Lordship, last day tomorrow.
So you submit your tender.
Lordship, but for that's why the 45 days is essential, because Lordship, several documents which is required, Lordship, land documents, and for that sufficient time is required. That's
When
why
was
that's-
the when
that's
was
also
the
reason
when was the
that
tender when was the tender issued?
35, Lordship.
35.
Yes. And Lordship, apart
You
from
had 1 month.
and apart from the clause 10, Lordship, clause 10 of the NIT, Lordship, which has been already been, there's two conflicting decision of this honorable court, Lordship. One decision, Lordship, I have annexed that is from
If there are two conflicting decisions, can this court decide?
but Lordship,
So which one should I? Which decision should I go with?
last year.
So it has to be referred to the division bench.
Last year also, Lordship, that said clause was incorporated, and we have challenged the same, and this honorable court has stated that particular clause there. May,
No. You said there are two conflicting decisions.
Yes.
Forget about in which case stay has been granted or not. What are the two conflicting decisions?
Lordship, one will be next Lordship.
You have next only one.
They are favorable.
I am put with Lordship,
Yeah,
but I am submitting Lordship. I have not.
you are submitting, but your submission has to be based on something.
Lordship, I have put in.
Now you have said that there are two conflicting decisions, but you have given only one decision.
Lordship, that was Lordship, that was subsequently dealt by this honorable court, Lordship.
Even not
when
mentioned in the petition also.
When last year,
Yes.
Lordship, we have challenged. Lordship.
Okay, he says there are 45 days required. You are not giving for what to do.
My lord, actually, my lord, there are two prayers and both are contradictory.
Okay.
Petitioners, because my lord, in one hand, my lord saying there are not sufficient time they are having, and by clause 10, my lord, we are giving 3 additional time that they don't want.
Lordship,
Why?
What clause?
By clause 10, my lord, we are giving 3, not only them, to
Yeah.
all the bidders, my lord, who will got the highest bid.
Yes.
So
So
additional.
how
Now they
does
don't
it cause
But-
prejudice to you?
But Lordship,
Yes.
clause 10 was the particular.
Mr. Counsel, right now, you're not even,
Lordship, if Lordship peruse the NIT, Lordship, sufficient documents, land documents is required, Lordship. For that, Lordship knows that for Jamabandi, etc., Lordship, for obtaining that sufficient time is required.
so they will,
And that's why,
so they will make the selection within 15 days.
but they,
So there'll be another they will tell them not to select.
they are violating the rules, their own rules, Lordship. Rule 40, rules 47 to prescribe, especially prescribe for 45 days, but they have any,
Yes. So the
My
rules
lord,
are.
that was done because of, my lord, the model code of conduct. Lordship is very much aware.
No, but then when the rules are there, what to do?
Yes, but as per the act, my lord, that we have
You
to.
you give another 15 days.
That we can extend, my lord.
You
That is
extend
not a big deal.
the opening. You do.
That we can extend, my lord. That we can extend.
The issue with clause 10 we'll have to see. Right. Heard, Mr.
K. Kolita.
Yes, what is the name?
K. Kolita.
K. Kalita, learned counsel for the petition, who submits that the what is the NIT dated?
35/2024.
35/2024.
Before
settlement.
passing the order, my lord,
Huh?
may I submit on the clause 10 judgments? My lord? The first judgment, my lord, my friend is referring, that judgment, in that judgment, clause 10 was not challenged, my lord. In that judgment, the clause 10, the remarks of clause 10 was not the ratio of that case, my lord. That was only obiter dictum, my lord. And thereafter, specifically, clause 10 was challenged in the series of cases which my friend that did not annex it, my lord. And in that case, court held, this honorable court held that clause 10 is valid, my lord. And thereafter, that was also challenged in division bench, that was also dismissed.
Okay. So clause, so that end of the matter.
Yes, my lord. So now, my lord,
It's only the 15 days.
yes.
The division bench has not decided the issue of clause.
Leave the matter on Friday, leave the matter on Monday. On which date? And this is the matter tomorrow. On which date? The petitioners have produced the conflicting decision of the single bench. Why you have given only one judgment here? Where is the division bench judgment? When there is a division bench judgment upholding a single bench judgment, now that issue is settled, then where is the conflict?
But issue of regarding the clause that was not decided. It was decided on the basis of that they have participated, Lordship. And Lordship, the last occasion also, Lordship has also dealt with that.
That is a different issue. That was
On
clause
the-
10 was not
on
involved.
the basis of that appeal, Lordship had closed that dismiss the petition on holding that since he has participated in that NIT, that's why he cannot turn around and the challenge. the clause 10.
Correct.
But in this case, Lordship, till date, Lordship, NIT was not started.
No, you please bring those judgments. Or you also bring the judgments.
Lordship, that.
Otherwise, we have got to take a decision.
Lordship may pick the matter tomorrow, my lord. I
Yes,
will bring
But
all the.
tomorrow, at 2, they will open, Lordship.
Okay, right. Heard Mr. K. Kalita, learned counsel for the petitioner, who submits that the respondents have issued the NIT dated 35/2024 for settlement of the Bata Dhaba Anchalik Panchayat Hut, no,
Several markets, including the Balisotto biofuel market.
several markets, including the
Balisotto biofuel market.
Balisotto market, Pusta. The Petitioners Council submits that in terms of Rule 47 bracket 2
Yes, sir.
of the
Assam Concert Financial Rules 2002.
45 days notice is required to be given prior to settlement of the market. Prior to submission of the bids of the tenderers. However, in the present case, only 30 days time has been given. Full stop. Where is that? Let me see the provision.
My book looks at page 264.
This one.
Page 264. New book looks at 264.
264 is no.
My book 264.
Your book might be something else.
New book.
Then one more thing, my lord, petitioner did not approach the authority also, my lord, because they have not annexed anything. Directly come to High Court only. Because it's already settled law, my lord. High Court is not sitting for deal with these kind of matters, my lord. Administratively. They have to approach first, my lord. Without filing any application to the authority that they want some additional time as per Rule 47(2).
Are you running the market? Huh? And what?
They all are connected.
Huh?
The lobbies are there, my lord. Different
No,
lobbies.
it will be there. Only thing is that we don't know.
Yes. Officially, I cannot submit.
Third party is done.
It says 45 days before the last day of the Panchayat financial year.
So at 15.
So that it can never happen. Then what happens?
They are supposed to close it 15.
Huh?
15.
Correct. But since it has not been done, according to this, it can never be done.
But they can extend those.
How can they extend?
Because
How can they extend? No, how can they? Where's the quick?
settlement period will be start from 1 second.
No, but then as per 47, if you want to go strictly, it says it has to be before the last day. It shall be floated at least 45 days before the last day.
That is the 30th June.
That is
the 36 2024.
Huh?
Last date will be 36.
Correct, but at least 45 days before.
Yeah.
So it can never be done.
And because of the model.
It can never be done.
Earlier also, last location also, I have annexed the 29/4/2000. They have floated on 29/4/2023.
That is all right. 29/4
Yes.
is all right.
Now this year also they can float from 15/5.
Why? It will not be as per 47.
45 days.
No, that is no.
It will be 45 days. So 15/5.
We take it up after some time at 2 o'clock. Let me read through it. Next, at 2 o'clock.
We pass over the matter for timing.
Item?
23.
I think it's there, huh? My first this is there.
There is also a similar matter.
Similar matter already.
Huh?
Already adjudicated similar material.
Acha, that missing autonomous council.
Already enacting issued.
Who are you? You're for the respondent.
Yes, sir. SC fishery. Mr. P. Sharma is in.
Huh?
For Mr. Pranjal Sharma, your lordship. Standing counsel fishery. He is coming here, lordship.
Now, what is your case?
Okay, what happened, this case NIT issued on 6/6 by Missing Autonomous Council. Thereafter, already state government already given settlement to me already, the petitioner, as per rule 12 of the fishery rules. I am already on running the fishery, your lordship, the government fishery, 60% registered category fishery.
Give me that missing autonomous council, we have passed that order earlier. Missing, the fisheries, missing autonomous council. Missing autonomous council, but I think that I will have that long order.
This is already settled, your lordship, is
Page 27.
The order is next. Twenty-seven?
Page 27.
I've got 27. 27 is, it's part of the petition. What are you reading? 27 is the. I don't know. 20, what, which petition are you reading? It's not here.
this case at the page 81, your lordship, only serial number 99, 100, 10.
We'll wait for Mr. Sharma. Next.
Identity and 25%.
Lordship, last topic and direct let ask Malak.
Yes.
Check Malak that removal of the embankment Malak.
So has it been removed?
Malak, that was Malak, endeavor was made, but could not do Malak because of the resistance by the local people Malak. This is the report Malak.
It is fixed today, my lord, for compliance to the court's order.
Lordship, that is.
Lordship directed to.
It will.
I filed an application for implement, my lord. Society which is working within tandem with the Kaziranga National Park and Forest Department, pursued by the Kaziranga National Park, the society. Development committee. So we filed an application for implement.
While I am highly objected, while there is no locus standi. I am the settlement holder. This is of my fishery. I am running my fishery. But due to ban, they are now your person to your lordship order.
Who are you? Who are you?
There is no locus standi.
Let us see item 20.
Item note 3.
Item 25. Item 25.
Yes, you have to come to paragraph.
No, tell me who are you? What is your name? What is this? This Dal Mohan Chetri, Keshav Ruth, these four persons.
4%, Dalmon is the president of the Eco
Huh?
Development Society, EDC, and my lord, the others are member. You also kindly come to para 3 of the petition.
Para 3.
This annexer 1.
Okay, so you are, what are you basically?
President of the Eco Development Society constituted under the guidance of the Kaziranga National Park. And beat officer is the member secretary. Annexer 1.
What is the locus in my lord, fishery, my lord? Why they are preventing my lord?
This
This is my fishery.
Just let me hear them. Yes,
You also kindly come to page 15.
15, yes.
This is the society, my lord,
Yes,
registered under the Kaziranga National Park.
yes.
Tiwari Park, the Eco Development Committee of Assam Wildlife Division, Bokakhat, Northern Range, Pani Bharan, Vishwanath is hereby registered under the provision of Rule 7
So what do you want to say in this case?
we want simply to get implemented.
I know, why? Why do you want to be
Because
implemented?
the bond that they're talking about, if the bond is broken,
Ah.
then entire area will be flooded.
Okay.
Huge, because the project report, this.
But they are saying that the bund is within the fishery.
No, the
Okay.
fishery includes within the greater range of the project. It's
Huh?
very big project.
Okay.
People are-
So they are wanting the fishery to be extended,
Yes,
illegally extended. That is your case.
yes. So they cannot do it. Bond, if then there will entire area will flooded. That is our
Yes.
case.
Yes. You want to file your written objection, you can file.
My lord?
Otherwise, I'm impleading them.
No, I am objected. I
Then
file
you-
objection petition.
You file objection.
Yes, my lord.
Let them file.
My lord,
I have placed it Malak as part owner for the.
Anyway, now we'll have to decide this aspect.
All my lord administration go to open this band, but they are pressurizing. No, my lord. What authority? This is the government fishery. I am settled. I am the tender after completion of the highest value bidder. Thereafter, I am running my fishery, and for the development of the fishery, forest has given the assurance to open the bid for time being, and now they are in pressuring the UN tribe. How is the Lucas? Why am I file objection?
Okay, right. Mr. R.P. Sharma. In the item 25. Mr. R.P. Sharma, the learned counsel for the applicants says that they may be impeded. Learned counsel for the 4 applicants.
Yes.
Says that they may be impeded as respondents number 6, 7, 8, and 9.
Yes.
In WPC 4940, Act 2023. As they have got an interest in the issue raised by the petitioner, he submits that the applicants are the members of the TEWARIPAL, TEWARIPAL, Eco Development Committee of Eastern Assam Wildlife Division, Bokakhat. And the basic object of the society is the conservation of protection of forest and wildlife and implementation of development work in fringe villages situated around the newly created 6th edition of the Kaziranga National Park. Which is the paragraph, important paragraph for you?
10 years of income.
10.
Yes. And
No, how does his fishery, how is his fishery?
yes, madam. Then in the report of the government of India, madam, this is dealt with. Then page 10.
Page 10.
Yes.
Here.
This is quoted. 3.22%.
Yes.
Exception in blocks. The grazing area this bill will be pond is to be made into 4 blocks. These are the blocks, madam. Of one.
No, what are you trying to say? What are you trying to say? Instead of reading this, what are you trying to say?
Madam, this
They want the embankments to be removed.
no.
Why don't you want the embankments to be removed?
If it is removed, madam, then it will cause huge flood in place of Brahmaputra river water.
Good stuff. He submits that if the prayer of the writ petitioner for removal of the embankments on his fishery is allowed, the same will cause huge floods. Then what else? Huge floods. Huh? That's all. It will cause huge floods. That's all.
Hello?
Is it within the
Yes, within
forest reserve? What is it? You are not saying anything.
Yes, but within the range.
Within the range. Where is it in your affidavit? Where is it in your affidavit, in your averment?
Implement, it's not a very big implement application only, madam.
But you have to give a reason why you want to be a pleader.
Then we'll file it.
It's not that you can ask for the asking, I want to be this, I want to be that. You can ask to be president of America also.
The
We
amendment
cannot
is
allow
the-
this like that.
Amendment is the part of the minor project of the government of India.
No, my lord, their
Yes.
intention is
Yes.
that, my lord, they are going to fishing, my lord, illegally, my.
No.
This is
Not
the,
like a
you
project.
see your this.
Yes.
These are the person.
We are not there.
They are the utilizing the whole fishery by encroaching, by huge loss of the government money.
Okay.
This
One
is the
kilometer
there.
area, madam.
And last day also, they are all government along with the force going person to your lordship order.
What is there?
They are
Implementing, madam, what?
preventing the
Why
department
specific- why
government
is-
and law and so order is.
Mr. Counsel, one
These
thing.
are this.
Just a minute. Mr. Counsel, one thing. Why do you want, supposing the embankment is removed, flood water will be there, then it will go off. It will dissipate, then what happens?
But madam, in 2012, there was a great damage to the entire area. About
How much area will be affected? You have said nothing here. You have said nothing here. All your everything, the reason for your impediment is coming through your mouth only. Nothing is here in the pleadings.
No, nothing in pleadings are there, madam.
There's nothing in the pleading.
Nothing.
What is the reason?
No, Lucas Tendai also,
No,
madam.
no, I'm just giving.
No, Mr. Counselor, don't give me that. Please tell me from your pleadings, why you want to be pleaded?
Because we are in, along with the forest department and the national park, we are working in together for the protection of the area and also flood and anti-poaching and employment generation through fishing, watershed management. These things are there. We have said this in my application.
No, he wants the embankments removed.
If
Where
they
have you
remove
said that?
Otherwise, why should I come? If they remove the embankment, it doesn't cause any loss. Why should we plead it?
Because of their coming, their personal interest is there.
No, prove
Because
it.
this is
So
the.
file your affidavit.
Yes, we are
Yes,
going to
yes.
file. This is
File,
the.
file it.
Kotwe misha kotha nokoi.
This is not 4%. This is public.
4%.
You will have to kindly see. However, in the project, not
My
a
fishery,
single
they are
household.
there.
Just-
All
just-
the force are there.
just a
DC
minute,
is
just a
there.
minute.
They are
a
going to
minute.
law and order situation, creating the law and order
No, no, no.
situation, madam. There is a report, madam. This is.
Report of
You
against us
submit the
and
report.
against the poachers.
All
Yes,
reports are there. No. This is the report. Person to law.
What the report says.
I have
my son.
objected, madam.
Let me argue, then you argue.
Definitely.
However, not a
This is
single
the
household of
report.
Tiwari
Yes,
Pal was
your
able
lordship
to-
go to it, madam.
Just a minute, madam. May I be allowed to read?
The government fishery, what their interest?
However, not a single household of Tiwari Pal was able to eat paddy for the last 10 years. Since the fishes such as grass carp, red-bellied piranha, etc., cultured in the nearby Dolapani, India bill, Dolapani bill, destroyed all crops.
Nearby Dolpani Bill. What is it? Nearby Dolpani Bill.
They open it and then allow the fishes to come to our field. There has
Government
been
say
a-
whether this is the government fishery or not. That will be the main task of the fishery.
There has been a continuous tension between
Government will
villagers and the lessee of Dolapani bill, and sometimes it leads to conflict. So considering all this, it is proposed to utilize the Huru Dolapani bill for the purpose of watershed management. Besides digging a few fisheries.
When can you submit your written objection?
Fine.
When?
My lord, 1 week time maybe.
Next week?
Fine.
Right. Uh, Mr.
N. Bora, madam.
N. Bora, learned counsel for the writ petitioner. Will submit that he will file a written objection
Madam.
to the application for impediment within a week.
Madam.
Uh, On a bare perusal of the application for impediment, it is not understood as to how the prayer of the writ petitioner pertaining to a government fishery has affected the applicant. In this regard, the applicant's counsel may file additional affidavit in the meantime. This is the matter on when? Next week?
Next week.
This is the matter on Thursday. This is on Thursday.
In the meantime,
Hi,
my lord.
can you write? Item number 3. No, item I is 25. Then the main order is at 23. Item 3. Item 3. Ms. Udas, learned counsel for the respondents, has submitted letter dated 15/6/24 issued by the circle officer, which is to the effect that removal of the embankment has been resisted by the general public, despite attempts to remove the same by the respondent. So, stop. Next, you write. List the matter again on same date.
Madam. my in that day, my lord, my learned friend will produce my entire my lord record regarding my settlement.
Let us finish this part first,
My lord.
one at a time. 27, 27.
Therefore, my lord, in this case, my lord, the matter may pass over a time being, my lord. My lord, senior counsel, my lord, can so my item breaks, my lord, in court number 7, my lord.
Item?
Item 3, 4 and 5. Lordship may dispose it today, my lord. Lordship may dispose it today, my lord. So at least my time being.
Otherwise, IFCS,
It'll be there, you just mention it.
IFCS already filed the affidavit, my lord.
He's in court number 7, man. He's coming. Just. apply.
Time being.
5 and 6.
This matter has to be heard finally.
By?
It has come for, it has to be because on the hearing, both are hearing,
Which are both are hearing matters.
Meetings are complete.
both are hearing. Meetings completed. My lord, that wine shop allotment.
Why show allotment?
Allotment, where my lord, technically my bid was rejected only on the ground that a consent from the pata holders.
Those four pata holders had not been given.
That is not necessary.
I don't know, let's see.
That is not, your lordship will kindly.
So you want it in the hearing?
It has to be hard finally.
We'll hear it. When do you want to hear?
The government,
If not today, then it's have to go after the vacation.
No, it depends upon, you want to have a hearing, we can do it also. Depends entirely upon you. Huh?
The government is the government on last occasion, they were saying something different. We took time.
It's not to say my lordship.
On the notice inviting tender, your lordship will kindly take item number 6. Both are same.
Item 6. Where's item 6?
Deepak Subbaman.
Yes.
On the notice inviting the bid was at page, it is at page 29.
Yes.
Both are same, my lord, so I'm just pointing out.
Both are same,
Both are
you mean, different, I mean, the issue is the same.
Issue is also same.
Issue is same, but the petitioners cannot be same, the land cannot be same.
Page 35, your lordship will kindly see page 30 important dates.
Page 35 or 29,
25.
which one?
29 is the my lord, notice inviting the bid
No.
for, this is for shop number SNP 2.
Okay, so we go straight away to page number,
Eligibility criteria,
page.
that is at page 37.
Yes.
Clause 39, clause 3, page 39. Eligibility criteria, lordship will kindly see page 35.
Yeah, shifting from 37
No,
to 39 to 35.
35, page 35.
Yes. 35, yes,
Important dates. My lord, column number 5,
yes.
date of seeking clarification.
End date for seeking
Yes,
clarification.
and date for seeking clarification. And that pre-bid meeting, all these provisions are there. What my purpose is to show. And the opening of the technical qualification, that is at serial number 10, 13 to 24. Your lordship.
So this is not the issue, correct?
But this is not,
Then-
I'm just showing my lord this matters regarding seeking clarification, etc.
That
provisions
is
are
a
there.
different issue.
Now, eligibility criteria is 37.
Page 37, yes.
37. And relevant is at page, he starts from page 37. Relevant will be at page, my lord, 39, clause 3. Terms and condition for grant of IMFL retail off license. These are the
So terms and
conditions.
conditions.
Yes. And page 40, next page, my lord. Clause 3.1.6. Yes, your lordship, may kindly note 3.1.6. Bid committee shall open the technical bids on the pre-notified dates as mentioned at page 35 in the bid documents. Then again, my lord, 3.1.7.
Yes,
That on the bids of the technically qualified bidders shall be opened by the tender bid committee at a pre-notified date.
correct.
Your lordship may kindly note, I will come to that, my lord. Page 44. Six point two point nine, my lord. Description of the site on which the proposed shop is to be set up to enclose. Now that I have given it at page 101. The description of the site, if your lordship looks into, that is there, site is there, at page 101.
Correct.
Now
That's-
6.2.12, my lord. This is what is important. Copy of the document showing the bidder's right, title, and interest on the proposed site or the land.
Bidder's right.
Bidder's right. So that is on the basis of the lease. That your lordship will find it at page 103.
103.
Please, my lord. He is the owner of the land. Man Bahadur Niwar. And the present member petition, lesser and the lessee. The lordship may kindly note. Clause 5. The lesser will permit the lessee to run the business of wine shop and construct houses and structures for the purpose of the same suitable for the business of wine shop, which will be constructed by the lessee according to his own convenience. Now, the affidavit is also there, that your lordship will find. This is, that may not be important, my lord. 110.
110.
That is the Jamabandi copy. The person who signed the lease deed, the lesser, Lal Bahadur Niwar. The lordship will find
Yes,
his name in the Jamabandi copy.
name of Patadar.
Yes. Now, what they are saying is that we have not taken the consent of all the patta holders.
Co-Patadar.
Co-pattadars. That is not necessary. Co-pattadars, plenty of co-pattadars will be, patta holders will be there. Now, the reason they have given is at page 137.
No, but then, does it
This
mean,
is the issue, man.
no, so the issue is that
If-
plot of land which has been taken on lease by you, is it owned solely by this Lal Bahadur Niwar
Yes.
or it is
Particular-
co-owned by others?
No, particular land, the Doug number, it belongs to that Niwar.
That dark number
That's it.
belongs to
Yes.
Niwar.
But patta holder, your lordship knows, man, periodic patta and the patta holders may be many.
Ah.
it's a big plot of land, there will be dog and all,
Okay, so in,
So I'm not required to
pata will consist of different dogs.
different dog.
And so the pata holders of, it may be one pata number,
Yes.
but in that one pata number, there'll be different dogs,
Yes.
having different,
So what they are saying that you have not taken consent from the
other co-pata
other
dogs.
co-partner. That is not necessary. Matlab, if I sell my land here at Guwahati on Mr. Mishra from Guwahati, he will not take consent from all the
Co-pata dogs.
co-partner. I will not take from the co-partner. This is my own land. I will lease it out, I will rent it out. So this is the only issue. Page 137.
Yes.
This is the joint inquiry report. This was done behind my back. I've given affidavit to that effect. Page 137. Number 2, my lord. Proposed land situated at Muradol Moja Christians Basti Village 150, number so and so. Near the Patta, Sri Lal Bahadur Diwar, your lordship has seen that lesser, son of so and so, have taken into lease, even though NOC of the co-partners have not been submitted and no construction of building is seen. How can we construct, my lord? Once the allotment is given, the permission is already given by the lessor, saying that once it will allow it to construct the premises. That is there. And co-partners permission is not required, my lord. Consent is not required. That is much something. Why it is being necessary? Because I am taking a shop premises on rent. The whole co-partner does not, it is not necessary. Nobody can rent out or lease out a land. And are taking, with a condition that I will have to take consent from you. So this is what they, another portion I will show. What they have-
That is the only issue you said.
This is the only-
Then what do you want another
No,
question?
in the affidavit, what they have shown.
That let them answer.
Yes, this is the issue in other cases.
So the only issue according to you is that the
Co-partner.
the consent of the other co-partner are not necessary
Not necessary.
because you are the owner of that particular dog.
Yes, the lesser is the only. If that is done, nobody can lease out a land, nobody can rent out a,
So that is the only question.
that is the only.
Yes.
Lordship, the basis of rejection of technical bid, your lordship, was on the reports given by the circle officer, lordship. Because an inquiry was conducted as per inquiry, as per a circle officer report, we have rejected this bid.
So what was the report? What does the report say?
137 is the report. It's a circle officer. We have taken action upon the report submitted by the circle officer. There is
I
page
agree,
137.
you take action, but what does the report say?
The report says, your lordship, at page 137. Point number 2, proposed land situated at Mohadal Moja Christian Basti Village,
Yes.
150 number Miyadi Pata, 87 tag number Pata 1 Katha Miyadi Pata, Sri Lal Bahadur Newar,
Yes.
son of Man Bahadur taken into lease, even though NOC of the co-partners have not been submitted and no construction of building is seen.
Okay, so now let us see a rejection of their bid, technical bid. The technical bid.
This is the only.
It's not a two package system, only one package.
Technical.
Technical.
Thereafter,
Two bit, is a two bit system or a one bit system? So what is the reason for
143,
disqualifying the
page
technical?
This is the only reason.
143.
143. No, that is a report by circle officer. We do not know the reason given by the by the
143 is a-
respondent.
I'll read out the lordship.
140.
Grant of highway retail
143.
license at Ramasuka, Morisuki, Mangalbaria. Detailed remarks. According to joint report inquiry provided by the circle officer Nodwar Inspector of Excise, Tezpur by so and so dated 28/2/2024, the report is not satisfactory. It is also found that the site plan submitted by the applicant is marked as wine shop, whereas the proposal was for the IMFL off shop. Also, one complaint has been
What do you mean by IMFL off shop?
off shop is off the premises, lordship. On shop is on the premises, off shop is outside the premises. So
So what do you mean? You're going to sell it in open air or what?
no.
Then-
So we have taken outside of the premises, your lordship. It's a carry, it's bar, it's a wine shop, your lordship, actually. It's a wine shop.
Wine
On-
shop, open air wine shop.
No.
Then,
But construction has to be done. There's a shop should be there.
so construction, so it'll be it's a open area
Yes, your lordship.
where a construction will be done after he gets the license.
Yes, your lordship. Also, one complaint has been received from the office of the Paschim Muradal GP, office of the Uttar Muradal GP forwarded by the BDO Jamugari by title number so and so, so and so, so and so against the applicant. Therefore, technical bit of Deepak Subba is not considered, Your Lordship.
He is not considered.
It's not
What is the
considered.
reason for disqualifying him?
It's not considered just because first their report says that the site plan which he has given, Your Lordship,
The
site plan
Huh?
which he has given, Your Lordship, the site plan is not satisfactory at all as per the inquiry conducted by the committee. Committee.
but the committee only says that no objection from the co-patadars has not been taken.
They haven't taken
That
it.
is so that is not required. It is his land.
But there's another issue is that complaints have been received. Your Lordship. 2 complaints have been received.
So you have got to put it to him. What is the complaints?
The complaints.
Where is the complaints?
Yes, in the affidavit, Your Lordship. The complaints which you have
Huh?
received, the affidavit which the department has filed, Your Lordship.
Hmm.
At page.
No, now come to the second para. Please just read.
According to joint inquiry report, Private Circle Officer Nadwar and Inspector Excise Tasteful. So and so, and based on a scrutiny documents, Vedar Rishikesh has qualified a technical qualification with as per para 27.
That is different.
That is different.
Rishikesh Bora is different.
That's a private respondent, Lordship. 27.1, the bid of financial to those who will open a language, but technical, their financial bid shall be opened on the bidder of Rishikesh Bora.
No, tell me why he has the petitioner's bid has been disqualified.
The reason for disqualifying petitioner bid is that this to the report which we have conducted an inquiry. The
circle officer's report.
officer report was there.
Circle officer's report is failed.
Saying that-
According to this court, failed.
Yes, Your Lord. They
So
said that
it is 1-1 in his favor, 1-0. What is the next point?
this is the only point, Your Lordship. And another
Oh.
point is that the complaint received from 2 Gram Panchayat, Your Lordship.
What is the complaint?
The complaint is in affidavit we have filed, Your Lordship, at page. At page 157, Your Lordship.
157.
Yes, Your Lordship. Let me translate copy, Your Lordship. Annexure 127, if I may read, complaint letter. It is most respectfully submitted that
Just a
as
minute, I'm still 157.
of the
okay.
affidavit in opposition, we have filed, Your Lordship. By department, Your Lordship.
Affidavit opposition. Yes, 157. Yes.
Yes. It is most respectfully submitted that as per reliable source.
No, which para? It starts like this. This is 157.
157, Your Lordship. This is annexure A 157. Annexure A, Your Lordship.
Okay, so it's been renumbered there. Okay, yes.
It is most respectfully submitted that as per reliable sources, we have come to know that a resident of number 2, Daulabari, Poliabhumra, named Deepak Subba, has filed an application for establishment of foreign liquor shop at our Mangalbari locality. The person is not a resident of our Panchayat area, and for that reason, we completely oppose such a proposal because in the future it might harm the Mangalbari locality located within our Panchayat. Therefore, if a local resident gets a permission setting up of such wine shop, we have no complaints, Your Lordship.
Okay. So they don't object to the setting up of a wine shop, but it should be from a local person.
From a local person.
Now, is there any bar for a non-local person to open up a wine shop there
There is no bar.
as per the rules?
There is no
Then-
bar, but there's a rule which says that the complaint which a person receives on establishing a wine shop, that is within 75 meters.
But this is in violation of the Article 14.
Sure, Your Lordship. That's why we have caused an inquiry. into the complaint.
Now coming to that. So according to you, this page 157 is the complaint. And there's another complaint.
There's another complaint, Lordship.
At page 150, 166. 164, 156. Okay. What is this 166? What does it say? Same thing. Local.
thing.
If a local gets.
This is going to be local there, Your Lordship. Okay, sir.
Now tell me one thing. Now you come to page 35. Come to page 35.
Yes, Your Lordship.
Come to bid meeting. Loan bidding. Technical bids opened on 13
13 to
to 2020. Now, only on this ground. Now you are saying that this 157 is the complaint. If there is a complaint against if there is a protest against the opening of a wine shop. What is that relevant provision in the rules? I think it is with regard to opening of a wine shop, it cannot be with regard to discriminating between a
So
local and a
yes, yes.
non-local. So I don't think the
That-
provision
that is
that you are going to read is of any help to you. So 2-0.
Another issue
Tell
is,
me another issue. Any other issue?
any other issue is that if I take a lordship to affidavit a lordship. The only reason, the issue is that a lordship circle officer, which has given the report as an inquiry which was conducted by the Aswari committee conducted by circle officer.
Has been.
That according to that report, your lordship, since he has submitted site plan, he saying that this is the site which I'm going to build the shop. But as per circle officer report, your lordship, let's say
He has not taken the consent of the
Yes, but-
co-operator.
and there is no construction can be seen, your lordship.
Huh?
There's no construction can be seen.
Correct. Only when he gets the license, he'll construct. That is what you have said also. The time for construction will begin from the date he gets his license. Not prior to that.
There has to be some boundary wall, some markment, so there has to be there.
You see, the circle officer's report is only to the extent that he did not take the consent of the other co-patadar.
Yes, your lordship.
That is not a requirement. That is not the co-patadar's consent is not required. Where does it say that's required? Where is the law which says
It's
that
not
it's
said,
required?
but what if tomorrow after opening a shop, the co-partner comes and no, they have taken-
Have the co-patadar said that this dark number is theirs? Is it the case of the circle officer that that particular dark number does not belong to that Bahadur fellow? That Bahadur Niwar or so-
That
whatever.
has to be, there has to be some circle
No,
officer,
okay,
lordship.
it's a council. Yes, yes, it's your, now it will depend upon,
My lord will kindly come to page 103, my lord.
your Mr.
And Deca, my lord.
N Deka for respondent number
The respondent number
5.
5. Not 5, my lord. 8, my lord.
8. Yes,
Only one
page.
thing, my lord, one thing. Page 103. The petitioner shows that he has taken on lease, my lord.
How does it matter?
Lease has to be a registered document, my lord. This is a notarized document.
That is not a ground.
I understand, that is not a ground.
No.
But prior to taking the lease, he has to take the permission of the deputy commissioner, my lord. It's a requirement of the Registration Act. If that is taken, my lord, the ownership is proved.
That is not a ground.
From the documents on
Which
record,
one?
how does the petitioner establish that he is the owner, my lord?
Huh?
Lordship will kindly come to the Jamabandi at page 111.
There's an agreement made between him and the owner.
Now, how does he prove that he is the owner, my lord? The Newar fellow is the owner, my lord. There are 10 names in the Jamabandi. Five dark numbers, my lord. Who is the owner of which dark?
Okay, let us see.
Let us see. Lordship will come to 112, my lord.
Page 112. Oh, 113 or 103?
112, my lord. That is the SMS version, my lord.
Oh,
I'm not reading the names. I'm just showing the numbers, my lord.
page 112. Yes.
Lordship sees there are 5 darks, my lord. In SMS, my lord.
I have no idea. Okay.
The fourth column.
Where is the translation of this?
Translation, my lord. Entire copy is not translated. It starts at page 110, my lord. Lordship sees the 4th column, my lord.
Oh, in the
In page
vernacular.
112, my lord, I'll explain, my lord. The 4th column.
1, 2, 3, 4.
Four.
Yes.
There are, my lord, 5 numbers, my lord.
5 numbers.
These are the dark numbers.
Okay.
And the column previous to them, these are the names of the patadars. There are 10 patadars.
Okay.
Now, from this document, my lord, how is it established that this never person is the exclusive owner of dark numbers?
Let us see the agreement made between the lesser
Yes.
and the lessee.
Page 103.
Yes.
Paragraph 3, my lord.
Yes.
Whereas,
Yes.
after the names, whereas the lesser is seized and possessed and or otherwise will and sufficiently entitled to the property comprising of an area of land measuring 1 katha. Now, pausing here for a moment, my lord, if your lordship comes to page 110. The total land is 3 bighas, my lord, of that particular dag 875.
I don't know.
110, my lord.
Yes.
Translated copy. Second column is the dag number. Third column is the name of the patadar. Fourth
Yes.
is the dag number. And fifth is the area of land. 3 means 3 bigha. 4 is katha and 13 is lecha, my lord.
Okay.
So here it refers to only 1 katha
Where?
in the agreement, my lord.
He's given 1 out of the 3.
Exactly. Where is it
Yes.
stated, my lord, that he is the owner of the 3 bighas? There may be other patadars there also in respect of 875. So there, my lord, what I am submitting, my lord, that there is a dispute, my lord, as to whether he is the sole owner of the dag.
No. That's not what the circle officer.
Circle officer is not saying that he is the owner.
And
why the
that is the issue that you have brought
no,
out.
my lord. The circle officer is saying that he has to take the consent of the other co-patadars. Proof from this document that Newar is the owner of the the entire 875 dag number, my lord. If he has some document to establish that Newar is the owner of 875, entire 3 bighas, only 1 katha has been given on
Look,
lease.
all the records will be with the circle officer.
Exactly. That is why, my
So
lord.
why didn't the circle officer say that 875
My lord,
is
what
also
was-
owned by some others?
What was required of the circle officer to give, my lord, that I'll not be in a position. my lord.
Then
I'll
unless
not be in a position.
so
but if you
unless
go
there
by
is
the
a-
affidavit,
clarification made, how can they just kick him out?
no, then the circle officer has to come up with
Correct.
records, my lord.
Let them do that. And until that is done, why should he be kicked out? On the basis of something that they're not sure of,
Because
how can they kick him out
because
and come to a finding on speculation, on
that's not much
speculative?
speculation. If your lordship comes to
No,
page 165, my lord, that is the letter.
Another thing, Mr. 103, page 103, Mr. Das. The third paragraph, where the lesser is seized and possessed. Where does it say that you're the title holder or the owner of the land?
Your lordship will, I'll not go to others, page 165.
165.
The circle officer's report.
Yes.
Second paragraph. The proposed land under so and so. Pata number 150, dag number.
Just a minute, 165.
Yes.
That's in
150.
Assamese.
Near the pata number
No,
150,
165
dag number.
My
Huh?
thing is in English. 165 is in English.
Dag number
The
1.
problem is they have
875.
again renumbered my copy. Okay, 165, I've got it. This is the letter by the circle officer.
This is what is relied on by the department. 28-2.
In mine, it is 175. With reference to the subject cited
Circle
above.
officer also says that he is the owner. The proposed land under, but that is not a object, their objection also. The proposed land under so and so, pata number 150, dag number so and so, although has been taken on lease from Patadar Sri Bahadur Newar, son of so and so, affidavit indicating consent from the co-patadar has not been taken, and in the aforesaid dag number, construction of a house can be seen. This is what the consent from the patadar has not been seen. He also says so. Nobody is questioning his ownership of.
Nobody is questioning, correct.
Nobody is questioning.
None of that
Authority
he
is
is
not
a,
questioning.
none of that
He's a
he is a
beneficiary,
patadar,
madam.
no one is questioning.
He
Who?
is not
That
beneficiary.
Newar
He's a
is
dog holder.
No, that circle officer report does not say so, madam. Circle officer.
But then where
says-
does it say he's not the owner
No,
also?
no. No one is questioning that he is not a patadar. But so far as the entire 3 bighas, whether he is the owner,
He is a beneficiary, my lord.
because that 875, there may be other patadars also, my lord.
So let the government clarify till the clarification is done. Nothing should be done.
Not anyway, nothing has been done, my lord.
No, that is what.
Anyway, nothing has been
So let it be clarified by the government.
Records come because circle officer is
No,
not a
no.
party.
Huh?
Report is not under challenge.
Is the circle officer a party here?
No, my lord.
Master, the
Circle
department
officer is not a party.
Circle officer respondent number 6.
No, he is there, my lord, but they have not responded. I'm sorry, my lord.
The beneficiary is submitting with the lordship.
No, my lord, I'm not sorry. I'm
Why
sorry,
is
my lord.
Going beyond the.
No, he's thinking of dollar signs are disappearing. So naturally, if he has competition, if he has competition, then there's a chance of him losing all the advantages that he'll be getting. Anyway, yes, madam, I think now the ball is in your court. Okay, right. Heard Mr. B.D. Das, Leonard, Senior Counsel for the petitioner. Mr. R.R. Goel for the Excise Department. Mr. R. Deka for the N. Deka for the respondent number 8. And Ms. U. Das for the respondent number 6. Okay. The 5 and 6. The
Not five, not five. 2, 3 and 6. He is the district collector.
3 and 6. The petitioner is aggrieved with the disqualification of his technical bid for grant of IMFL retail off license.
Shop number SNP 2.
No, forget that. On the ground that the same has been done on the basis of the circles officer's report. Circle officer's letter or report,
Letter, madam.
letter dated,
28-2.
just a minute, 1/6/160.
137.
28-2, madam.
The problem is your pagination, my pagination are different. When you go to 165, mine it is 175.
We'll have to correct it as per your lordship.
Yes, you have to do that. With this page 165, no, according to you, according to this. With
It's a letter
it
dated
pertains
28-2.
to the letter dated 28/2/2024 issued by the circle officer. The said letter states that though the petitioner had taken the land covered by Miadi Pata number 150, dark number 875, number dark part 1, Katha of land, from the Patadar Shri Bahadur Niwar, son of Mon Bahadur, comma. No consent had been taken from the co-Patadar, and that there was no house constructed on the said land. Full stop. That's the only ground. Full stop. The petitioner, next para, the petitioner's counsel submit that when Shri Bahadur Niwar is the sole owner of dark number 875, comma, there is no requirement of having the consent of the co-Patadar who might be many. Full stop. As the issue of ownership of dark number 875 is only with Shri Bahadur Niwar, who has given the same on lease to the petition. Next, Mr. R.R. Gogoi, learned counsel for the Excise Department, submits that the disqualification of the petition's technical bid had been done on the ground that on the basis of the circle officer's letter and report, which stated that the consent of the co-Patadars had not been taken at the time of leasing dark number 875 by so-and-so Bahadur Niwar to the petition. He also submits that two complaints were received. The two complaints. Where is those complaints? 112. No, not 112. Huh?
57.
Yeah?
It is 157. Then it may be 167 also. 157 in my.
164. 164. Complaints received from Secretary Paschim Murhadol Khan Panchayat and Secretary Uttar Murhadol Khan Panchayat. dated, both dated, no, dated 22/2/2024 and 27/2/2024 respectively. The said letters, the said complaints stated that they had objected to the setting up, the establishment of a liquor shop in their locality by a person who was from outside the locality. However, they did not object. They would not object if the liquor shop was opened by a person who was a resident of the locality. Next paragraph. This court is of the prima facie view that the grounds for rejection by the excise department does not hold water, inasmuch as there is nothing to show that DAG number 875 is owned by some other person other than Shri Bahadur Niwar, son of Mohan Bahadur. Further, the complaints not having objected to the setting up of a wine shop in their locality by a local resident, the reason for denying, no, the reason for disqualifying the petitioner's technical bid on that count would amount to, would be in violation of Article 14 of the Constitution. Full stop. Be that as it may, Ms. Udas, learned counsel for the circle officer, shall obtain instructions by the next date and bring the records, the necessary records, to show as to whether DAG number 875 belongs to some other person other than Bahadur Niwar, son of Mohan Bahadur.
May I make a submission? There in the Assamese portion, which they have not translated, madam, there it shows that my name has been mutated along with Lal Bahadur Newar in respect of another document.
They'll clarify
Can
everything.
they get that instruction also, madam?
But
Page
your
112,
name?
with regard to 112.
Your name has been, where
My
do
name
you?
is Rishikesh Bala, madam. My name has been mutated in the same 112, my lord. My name also appears. The name of respondent number 8,
112.
page 112.
But how,
Number 10.
how are you agreed?
No, my lord.
You have got nothing to do with 875.
No, what I am on, whether 875 is wholly owned by Newar, madam.
That is what I've
That
asked.
they will clarify.
That's what I've said. That's the question I put to them. List the matter after the list the matter when after vacation.
Status quo order.
Status quo, the interim order passed earlier shall continue till the next
I
day.
don't think, madam, there was an entry.
Acha, then there's not
There was an undertaking given by Mr. P.
okay, then we'll stay the thing. List the matter on so and so. And till disposal of the case, the
Status quo, madam, but nothing.
this status quo as on date shall remain.
In the second case also, my lord, page 111.
Okay, page 111. Okay, just a minute.
Same ground.
Again, two complaints. Okay,
There is no
no complaint. Only thing. What is the DAG number here?
111 is the detailed remarks from
Huh?
the. It shows, my lord, according to the joint inquiry report provided by the circle officer, so and so dated so and so, there is land related discrepancy, report enclosed of the applicant Sri Biju Shetty. Therefore, the technical bid. of the
Page
applicant is
112.
111.
You all say something and then
My lord, that pagination, my lord, from this time, I'll have to be very careful.
111. 111 is this 111. There's nothing written. This is 111.
Tag number 167.
Which
Lordship will
page?
find that at page 92.
92.
That is the tenancy.
I think, you see, one thing, please tell your juniors to please coordinate the pages. It should be as my report. Or you come, you invite me, I'll come to your house and I'll make it into your pages. We're having a difficulty right here. Yes, which
92, my lord.
92. Ninety-two is this.
92 is part of the writ petition, my lord, it should match.
What? It
92
is part of the writ petition. Only
No,
thing, this is the
affidavit.
92.
Affidavits are numbered serially, my lord. Writ petition should match. my lord. Lordship is taking up
1586.
1585.
1585 was the one we were doing. Okay, this is
Six has
6.
been done.
Visual settlement.
Biju Chetri, my lord.
Okay. One number,
So then there your lordship will tell us see page 111.
111. Yes.
Yeah, that is the reason. According to the joint inquiry report provided by the circle officer dated 28/2/24, there is land related discrepancy of the applicant to the visual settlement. Therefore, the technical bid of the applicant is not considered. This report your lordship will get it at page 127.
Yes.
Same, my lord. Serial number 2, ultimately, my lord, it says has not submitted the consent from the co-lessee.
From the
Co-lessee.
co-lessee? Co-lesser.
Yes, sir.
Co-partner.
It has to be co-lesser. Cannot be co-lessee. You're the lessee.
That's what, man. There is no reason, man. There is no ground to say that I'm not the owner of the land.
Yes. What are the ground?
Same grammar.
Huh?
SMS says Patadar, my lord. Why it has been
Acha, from the
translated-
co-patadar.
Co-Patadar.
Okay.
SMS says Co-Patadar.
Okay, right.
Co-Patadar.
In the item number 5. Same, huh? Party the same. Then you write, the rejection of the petitioner's technical bid has been due to the fact that that as per is due to the circle officer's letter and report dated 28/2/2024 and report, which is to the effect that the consent of the co-patadars had not been given for leasing out dark number 167. Is it dark number 167 to the petitioner by whom?
By the Co-Patadar.
No. The original. By whom?
Owner is Krishna Thapa.
By
Page 91, Krishna Thapa.
by Krishna Thapa, son of. No, just say Krishna Thapa. Krishna Thapa. Huh? Full stop. Miss Yudas shall obtain specific instructions and produce the record as to whether dark number 167 belongs solely to Krishna Thapa or to some other persons also. List the matter. Same order, huh? Status quo. Same.
168,
167 or 168?
7.
page 95,
Page 92.
page 95.
Let us see what does your lease deed say, your agreement say? What is your agreement?
91, madam.
Page 91.
167. Schedule is at page 92.
167.
167. So that's how.
Document which has been submitted, page 95, show 168.
Here there is a discrepancy.
Where is the report? Circle officer's report?
127.
120.
Oh, 167.
My lordship will reads further, my lord, the second subparagraph of 127.
Yeah.
The tag number 167 has been taken over for the establishment of, but only on the tag number 168 is being prepared for establishment of shop. So the shop is being established in a different land. They have given land of different land. Agreement of different land. And lordship reads two also, my lord. The proposed land under so and so, 167 is 1 bigha, 3 kathas, 12 blechas, are mutated in the name of Gopal Thapa, Krishna Thapa, Bhupan Thapa, and sons of Ghanshyam Thapa. The applicant has taken 120 square feet of the proposed land on lease from Krishna Thapa, son of Ghanshyam Thapa, but has not submitted the consent. So this is on a different footing now.
It's slightly different. Page 127.
Yes. Let them take the instruction as regard the ownership of.
No, it's
When
here.
it
The
becomes
circle
a
officer has
number.
written here. The circle officer has written, proposed land under so and so, dark number 167, are mutated in the name of Gopal Thapa.
Yes.
Number 2, Krishna Thapa, 3,
4%.
Gopal Thapa and Ghanshyam Thapa.
4%.
Correct?
But they say co-lessee.
That
Correct.
is a translated part.
That is
a
that
part.
is understood. Co-lesser.
But if these 4 dark numbers belong to 4%.
Huh.
These 4%. And I am the owner of that particular dark, 167.
Correct.
That is lesser.
They are 4% owner of dark number 167.
So, for 167, my lord, all these divisions are there. Your lordship will get it at page 96. That is
96.
in Assamese.
Again, Assamese.
In Assamese, 4% names are there and 4 dark numbers are there. Krishna Thapa 168.
Okay, there are 4 dark numbers.
Yeah, 4 dark numbers.
Okay, you get
Other
whatever I
reports,
written.
please,
You.
otherwise, my lord.
Let him get, let her get.
Report is.
We will decide on the next day.
MB 23.
And it will come after vacation.
That's what, 18th.
18th.
Item 23.
Yes.
What has happened here? He has been settled with the fishery. And it is in the,
Similar.
it is in the tender notice.
That NIT.
Huh?
That NIT.
But why are you not deciding to give the missing thing, the missing autonomous councils?
We cannot, Lordship. It is not under 6th schedule. We have no power.
No, it is the
Because the
government.
sixth- No, Lordship. For 6 schedules, it is 6 schedules, there are only 3 districts.
No, Mr. Council, it's not that. Under the 6th schedule, that's a different issue, no doubt. But for the missing autonomous council,
Not,
they have got the act,
not.
and as per the act, as per the section 79 or whatever, I think they can make proposals. Correct?
Not.
And if they make proposals, then the government has to decide whether to approve or not.
But they have, government has not authorized them as per section.
Correct. Right now, they have not authorized
No,
them.
government has not, as per what is done, it is illegal, Lordship. Because as per 23.
Yes, what about the government? Yes, missing autonomous council, who is there? Have you made any proposal to the government to have it to control the fisheries under your area?
Or whatever the case may be, they should not act without our approval, Lordship. That is our case, Lordship.
We know, that much so I know. I am on a different footing. I am saying, now these are areas under the missing autonomous council. There are some areas, okay, there might be some,
Not similar.
there might be some differences with regard to areas between the state and, but areas which are completely within the missing autonomous council. Why isn't the government giving them authority to look after the fisheries?
Lordship, here, we have another problem, Lordship. In the similar footing, there are another Boru, Tengal, Kasari, several autonomous councils are there. If these things happens, there will be no fishery lordship. Everybody will go.
No, they will have their own fishery. They're the government
if
also.
The way NIT was issued lordship,
Uh-huh.
tomorrow Boru, everybody will issue NIT lordship in that case. Lordship. Then
No, I'm not on that. I'm not on that. I'm on a different footing. I'm saying that they also should be allowed to look after fisheries on their own. But for that, there is a way to go about it. You know,
But there is no proposal. Actually, as per section 80 lordship, for anything to be done, fishery rules has to be amended. So that was also not amended. Lordship. Section 20, missing autonomous council.
you see, you can ask the state government to make rules under section 79 for having control over the fisheries within your area. We can direct that also, but that will be at the end of the day. But then you've got to make a proposal first. The proposal has to come from you. Until then, you actually don't have the right to settle fisheries. It appears so, unless you've got some instructions to the contrary. I don't know. Okay, right, mister. Now, where is the tender?
Tender number.
Lordship, the present tender, the UP order annexer O, page 78.
Number.
Okay, so where is the number? Your fishery.
CL number, Lordship, page 81.
81.
CL number 99, 100, 101, and 103.
$91,
99, 99,
99,
100,
100,
101,
101.
102.
100. Okay, this Kharoi Nadi Min Mahal, Kutub Min Mahal, Khata Nala Min Mahal.
Zabara Savana.
Okay, right. Heard, Mr.
Please, I can.
D. Saikya, learned counsel for the petitioner, who submits that the petitioner has been settled with the
Soidwar Kharodin Min Mohan.
Chaidwar Kharoi Bin Min Mahal for a period of 7 years,
7 years.
commencing from 8/9/2023, in pursuant to NIT dated 12/6/2023, by the AFDC or by the government,
The government, Fishery Department.
by the Fisheries Department, government of Assam. However, the missing autonomous council office of the principal secretary, missing autonomous council, hereinafter referred to as the MAC, has issued partial modified NIT for Mean Mahal bracket first phase bracket 2024-2026 dated 6/6/2024, wherein the petitioner's fishery has also been included for settlement in serial numbers 99 to 102 of the said NIT dated 6/6/2024. Not in the partial modified NIT dated 6/6/2024. Then you take for para two. Huh? And I don't think this is your submission, but we'll include it. Otherwise,
He has not brought up this council act also.
he doesn't have anything. Okay, don't say that. This is,
Not even recorded.
no, okay, on considering. No, the petitions council submits that the, okay, just take para two, huh? Partial modified NIT. Partial modified. This is it.
My submission in that. Maybe recorded.
No submission of yours. I don't know.
মজা কি ছিল? Other case, they are not recorded. I think in Bonnie case, like everything is recorded. Okay. In your lordship, another case is there. Bonnie portal. 3087. Lordship, another order was there. It is very clear. 3087. Bonnie. Doesn't it? The next one is clear.
Just a minute. Yes, yeah, Mr. As they forward the your respondent number? Five. You're for the fishery department.
Yes, sir.
Mr. S.S. Roy.
Only one.
Two to four. Serial number 99 to 102, na? Okay, we'll list it on 19/7 or the dates. So you cannot act upon 199 and 199 to 102.
Lordship may consult that order also.
Not. Well, it's here. 97.
Public lottery.
Miss
M. Kalita,
M. Kalita, Learned Counsel for the
PH Department.
PG Department, submits that she has not received instructions and prays for 4 weeks' time to obtain instruction and file affidavit. This is the matter of the 4 weeks.
7, 8 is also simplified. 7, 8, 9. Obliged.
Last time we made a request that we produce record.
The records are here, Your Lordship. We perhaps have to file an affidavit. So I'd like to go through it and file an affidavit. Notice has already been issued in the matter. And we had already submitted last time that we are not going to take any coercive action pursuant to the revised.
So you will not take coercive action.
Because that concession was already made by the learned additional application.
But there is an application for pleading the person, my lord, who was chairman of the empowered committee at the relevant time. He has retired. So we have come to know, because he is the person who will know whether he has uploaded it without the consent of the board or with no, no. So we have filed an application that for his pleading.
I don't know, but what is any
He
objection?
is not there. He is the person.
But he's basically only object is to support your case.
Yes.
No, but that's why I want, it's my petition and I want him, let him, may support, he may not support.
Lordship,
not
and then
saying
I will
that.
respond to it, Your Lordship, because his statement which has been made has been sworn by knowledge, Your Lordship. And he is saying from his knowledge that that person has personal knowledge regarding this.
Naturally, who will have, he
Then
is the chairman. Who will have knowledge?
Lordship may allow, because there appears to be some meeting of the minds between him and that person, Your Lordship.
But so what? What to do?
Lordship, because if an IA has been filed, notice may go, we'll respond to Lordship.
Okay. Right, where is the IA? In the IA, there's item 24. Heard Mr. D.K. Mishra, Learned Senior Counsel, assisted by Mr. S.K. Kejriwal for the applicant. This is an application for improvement of Mr. Mir Rafiul Amin Diwan, resident of flat number A1, Amravati Path, GMC house number 19, Christian Basti, Guwahati -781006 Assam, as respondent number 5, in as much as the said person was the Chief General Manager bracket COM and E bracket close APDCL and the chairman of the empowered committee.
Under whose signature, my lord?
Under whose
the resolution
signature?
Was uploaded.
The one-time settlement was one-time settlement made with the applicant was uploaded on the APDCL portal on 4/3/23. Issue notice returnable in 3 weeks. Mr. KP Pathak accepts notice on behalf of the APDCL.
Respond numbers 1, 2, 3.
Respond numbers 1, 2, 3 and
4.
Submits that 1 to 4
1, 2.
and submits that he will file the written objection within written objection, if necessary, within 3 weeks. This is the matter after 3 weeks.
My lord, we have filed one additional affidavit which has not come on record, but we have given an extra copy. Just your lordship to see it will come on record. I just want to bring it to your lordship.
There's not here.
It's there. We are giving a copy. I will just bring it. Your lordship need not pass any order. We're just bringing to your lordship notice. My lord, we have annexed an advertisement made by them, by APDCL in the Assam Tribune. Your lordship will kindly turn to page 123, page 50, annexation 50, page 123.
Yes.
This is Assam Tribune of the date of 27th April 2022.
Yes,
On the right hand side on the left, your lordship may see the date and your lordship will come to 125. Page 125.
125.
Yes.
Yes,
There's a big advertisement on the right hand side below it, special one-time settlement scheme 2022.
yes.
So these are the features. Then below that, if your lordship will see process for submission to resolution. Visit the portal, this thing is there, then select the dedicated tab, fill up all the information and submit. Unique application number with acknowledgement will be generated. The resolution under the scheme will be uploaded on the portal. SMS will be sent to the applicant for needful. Acceptance of the resolution will settle the matter. And this was accepted on 6/3. This is their, well,
Accepted by the.
professed, this is their professed action. And my lord, this was settled by Justice Frankfurter in Seattle versus that I don't remember some case which has been referred by lord with approval by the Supreme Court in two decisions. The recent is 2023. They cannot escape from this. And not only that, my lord, if the person is made party, many skeleton will come out of the cupboard. I'm saying, my lord, this thing is. This is the thing.
If there are skeletons, your lordship, they have to come out of the.
Yeah, we'll come out. But my lord, only thing is, if you lordship permit us, we want to peruse the record. Which is in his presence, we will, by learned friend, we'll see.
Lordship, we'll bring it on record by way of affidavit.
Because
Because
bring
lordship,
an event record. No, but what you will bring and what you will not bring, that will depend on you.
no, if that
You want
is
to see the
the,
record.
that is the. That, lordship may record it that they are, yeah, apprehensive that we are not going to bring anything.
Yeah,
We are-
yeah, I am saying that. I'm
Let
saying.
let them see what is there to hide.
Perusal of the record will not be.
No, because
How will it? Yeah, you want everything to be transparent.
we want, we definitely, your lordship.
And some wrongdoings might come out also.
Very well.
Okay, right. Mr. D.K. Mishra, in the main case, submits that additional affidavit has been filed. However, the same is not on record. Registry to place the same on record. This is the matter after the vacation. Yeah, after 3 weeks.
Lordship may perhaps record that I have the records available with me. I'll show this.
Mr. K.P. Pathak has also brought the record. And the petitioners' counsels, they are allowed to peruse the same. Then this is the matter.
Supplementary admission 26.
I think we're having too many things, no? The main hearing, we're not having anything.
But I've got a detailed wherever yesterday. I could not file it today, my lord, by preparing the affidavit. But the last occasion, lordship was directed, my lord, we'll have to file it by today. I've got it yesterday only. This is the entire paragraph. By Monday, I can file it, lordship will proceed on Tuesday.
What is this matter about?
Regarding
My
my
lord,
lord. without-
we have the
forest-
impugn
forest-
order, my lord, issued letter. They demand the forest
Forest royalty.
clearance certificates, my lord. Our contention is this, my lord, there is no such condition in the tender agreement that for us to requiring us to
Yeah,
protect.
let me file
Park
that.
system.
They have brought out certain minor clauses of the contract agreement, as well as some notification of the forest department.
And if
On Monday, I will, my lord, anyhow
Okay.
file it.
Mr. B. Gogoi, Learned Counsel for the PWD, submits
Yes.
that he has received parawise comments today, and he accordingly needs 5 days time to file affidavit in the position. Praise allowed. This is the matter. After 5 days. Motion days in that. Will be silent, reopening?
reopening, my lord, have a date of the 16th,
16, yes.
and deploy.
Oh, let's go.
Item 12 and 13 for order.
Your lordship, can you possible for the day, instead of the vacation?
For the day.
For
Huh?
the day,
Why for the day?
because my senior is on late, special bench lordship. Instead of the vacation, lordship.
This matter, my lord, that this is from contempt petition and all that are back together.
I don't remember.
FCI matter, the lordship pardon order, but I'm appealing for the one of the contempt.
Okay, the contract work was, okay.
Contract is over in 2023, my lord.
But the manner in which you have done it is,
So that, my lord, will decide in the, my lord, because that is under challenge in the writ petition, my lord.
okay, so what to do? Please.
No, no, I have no objection. It will come after vacation then.
Okay, right. Adjournment prayer has been made on behalf of Mr. A.C. Barbara, learned senior counsel, on the ground that he is on legs in another court. The same is not objected.
In the contempt, my lord, my name and Mr. Singh's name may be recorded.
Singh's name?
BK Singh, he is assisting me.
Same
For
is-
contempt number 3, my lord.
This is not objected by the so-and-so, senior counsel and Mr. B.K. Singh, learned counsel for the respondent number 3. This is the matter after the.
Please, Your Lordship. Lordship, we have already filed an affidavit on 18/6, for Lordship. Stating that they have, not appeared before the authority on the last date,
It did not appear.
No, they have
When he
appeared on
appeared on
10/6,
10.
Lordship.
10/6.
Before that, on several occasions, they have not appeared. On 10/6, they have appeared, Lordship, and prayed for time, 25 days time to file a relevant reports, Lordship.
Oh,
Relevant
so you
documents.
appear on 10/6
Yes, Lord.
and you ask for time,
For 25 days. So,
25 days time. So
25.
25 days has not elapsed. 25 days will be 1st July.
They have fixed the date also, 5th July.
Okay, 5th July, okay.
July.
Lordship, and if I may, title suit which was pending in the lower court has already been dismissed, Lordship.
So
But title suit, that one, defendant name is different. In-
title should have been filed by whom?
By the petitioner only, Lordship. So, some few documents are kept, some.
Okay, anyway, 5th, we'll list it after that.
Lordship.
Okay, right. Miss KLR Yanthan
Yes, Lord.
appears for the petitioner, while Miss S. Kemprai appears for the
Respondent.
respondent. The petitioner's counsel submits that the petitioner appeared before the Joint Secretary, Department of Revenue, KAC on 10/6/2024 and took 25 days time to submit additional documents. As the matter has been, as the parties are going to meet again on 5th July 2024, leave this matter after the vacation.
Affidavit may be
Huh?
recorded, or affidavit is not.
Full stop. One thing, before, you say, though Ms. S. Kemprai submits that affidavit of the respondent has been filed when?
18/6.
On 18/6, the same is not on record. Registry to place the same on record, unless the same is under objection. You check if it is under objection or not.
Kindly fix the date after vacation.
Don't put everything 19, put a little bit fast. 22nd.
Obliged.
Lord, in this case, what happened?
Just a minute. Yes.
So, BRPL installed an electric generation power in their premises. For that purpose, Bharat Heavy Electrical Company was awarded the contract. And the Bharat Heavy Electrical Company entered into contract with us. And in fact, we had executed this work on behalf of the Bharat Heavy Electrical. And after execution of this work, Lord, we actually are the person concerned who are employed by us, we call them to join in our head office. They express their reluctance to join there. And they approach before
No,
the-
who are you? You are the workman.
No, I am the, my,
Okay, you are the one who did the work. That's
I have done the work on behalf of Bharat Heavy Electricals.
okay.
And
huh.
after execution.
You are a firm,
Yes, yes.
proprietary firm or a partnership or what?
I'm a company limited.
Company, private company limited.
For private company. I have executed the work on behalf of Bharat Heavy Electricals. After execution of the work, I called upon my employee to join in my head office. This employee concerned reluctant to join there, and they approved before the labor commission, labor inspector for their due wages. And the labor inspector, what happened, call us, us along with the Bharat Heavy Electrical, we appeared before them. And the Bharat Heavy Electrical said all that we shall pay the amount. And thereafter the amount was paid. And now Milo
Amount was paid to those workers,
paid to the
to your workers.
by my worker. So far the worker is concerned. Now what happened, the labor inspector while recording the proceeding has stated that we have also agreed to that. In fact, we have
Agreed to what?
agreed for that payment to be made by the Bharat Heavy Electricals.
To the workers.
To the workers. There is our principal contractor, principal contractor. Now we have disputed this time. Now we approve.
Why actually the money should be given to you or what?
Yes.
Why have you disputed the payment to be made by Bharat Heavy Electrical?
Because
to
they
the
will deduct it from our dues.
Okay, okay, so you suffered.
So ultimately
How much?
1,91,000. 3%. Now we approach before this honorable court to the effect that actually the labor inspector had no jurisdiction to initiate a proceeding under the Payment of Wages Act. And so in fact, he has acted beyond his jurisdiction. That is our case now, and nothing else. The payment has already been made to the workers. Only thing is that the labor inspector has no jurisdiction to initiate the proceeding under the Payment of Wages Act. If your lordship goes through the provisions contained in section 15 of the Payment of Wages Act. And the state government has also filed their affidavit, and in that affidavit, they have also considered these things.
State government has considered that they could that now what is to be done? Supposing we say that okay, you're correct.
Actually, this has become infractuous.
So now what to do? How can you recover?
Can't recover it. Some who can make the record change and nothing else. Because the payment has been made by the Bharat Heavy Electrical, they might have recovered from us also.
You don't know if they've been recovered from you also.
That may be.
That also you don't know. Then how? Then where is their grievance in the first place?
No, Milord, only thing is that the labor commission, then if it is not recovered, but even if it is recovered, it can be adjusted. Because the labor commissioner, the labor inspector has no jurisdiction to initiate this process. That is our case here. If your lordship goes through the section 50 of the Payment of Wages Act.
Yes. Let us see the labor. It was done where it was done in the conciliation proceeding or what?
No, it was done through a proceeding under the Payment of Wages Act.
Proceeding under the Payment of Wages Act. It did not follow the Industrial Disputes Act. It did not follow that.
No, it did not follow the Payment of Wages Act.
Huh?
Payment of Wages Act.
It did not follow you said that he does not have jurisdiction.
Yes. That jurisdiction is conferred by section 15 of the Payment of Wages Act.
Now let us see the impugned order.
Page 15.
Award. Is it award?
Yes.
Page 15.
The finance of joint inquiry and negotiation. Finance is like,
It's a conciliation.
it's like,
Huh?
Yes.
Minutes of joint negotiation over non-payment earned wages and.
Principal employer is Bharat Heavy Electrical Limited. The lordship comes to at the bottom portion. However, in the discussion, the representative of the principal employer, Messrs. Bharat Heavy Electrical Limited, had committed to make made responsible for payment of the above claims entirely by the workmen, an amount of rupees 1,91,900 rupees. Other benefits will be.
So they are paid, so we recovered from the bills payable to the contractor. Okay, bills payable to the contractor. Now, so this has been made.
In 17th October 2013.
Where does it say that it has been done under the Payment of Wages Act?
It is requested represent the principal employer, Bharat Heavy Electrical Limited. The workers will be submitted on, I don't know. That you will also find at page 13. 12 and 13. Your Lordship, page 13, at the bottom portion, in view of the above, you are hereby requested to attend this office along with the connected documents for joint inquiry and negotiation over the above issue scheduled to be held on such and such date in the office of the labor officer co-treasurer without failing which the necessary legal proceeding shall be initiated against you under section 15(3) of the payment of wages.
Okay, let us see the section 15.
Section 15(3),
1.5.
1(5).
Yes.
No, 15(1). The appropriate government may by notification in the official gazette appoint any commissioner for workmen compensation. Any officer of the central government exercising function as the regional labor commissioner or assistant labor commissioner with at least 2 years experience. Any officer of the state government not below the rank of assistant labor commissioner with at least 2 years experience, or a presiding officer of a labor court or the industrial tribunal.
What is the difference between this labor court and an industrial tribunal?
These are two hold up. So if your lordship, industrial dispute act. If your lordship goes through the provision of the industrial dispute act, your lordship will find two schedules.
Two?
Schedule.
Okay.
One schedule is meant for the labor code for adjudication, and other schedule is meant for the industrial tribunal. May I go to?
Yes, yes.
Probably schedule just. If you want to know labor code and industrial tribunal, first come to section 7.
Yes.
Got it. Got it.
Yes.
Section 7 of the Industrial Dispute Act.
Yes. Labor court.
Labor code. The appropriate government may by notification in the official gazette constitute one or more labor code for adjudication of an industrial dispute relating to any matter specified in the second schedule. And for performing such other functions as may be assigned to them under this act. Now, if your lordship comes to second schedule,
Yes.
these are the matters to be adjudicated by the labor court.
Page 115 in my book,
115.
in my book.
Yes. Yes, Michael is 115. This, matters within the jurisdiction of the labor code. That is the propriety or legality of any order passed by the employer under the standing orders. The application and interpretation of the standing orders. Discharge or dismissal of workmen, including the reinstatement of or grant or relief to workmen wrongfully dismissed, withdrawal of any customary on concession or privileges, illegality or otherwise of a strike or lockout, all matters other than those specified in the same third schedule. Now, third schedule is meant for
This in the below that, there is this part B. Central acts offences were under tribal by labor code.
yes.
The payment of wages act.
The central acts offences were under tribal by the labor code. That is the payment of wages act.
So labor court can.
Labor code can, industrial tribunal also can, and regional labor commissioner can.
So in this case, it was decided by the labor court.
Not labor code, labor inspector.
At a labor inspector.
Labor inspector. Well, if you go to page 13.
What will be the difference between a labor inspector and a labor court?
Labor code is meant for adjudication.
It be appointed by the government.
By appointed government. And
So out
labor
here this-
officer is also appointed by the government. If your lordship.
Labor officer.
If your lordship comes to section 4, probably your lordship will get some idea.
Yeah.
That they call as conciliation officer.
So a conciliation officer.
That is a labor officer.
So out here, this case has been decided by this labor inspector come conciliation officer.
He might be a conciliation officer.
So if he's a conciliation officer.
I will come. Let us come to section 4 first.
Yeah.
Then we have to go section 12. Then it will be clear. Conciliation officer.
Yeah.
The appropriate government may by notification in the official gazette appoint such number of persons as it thinks fit to be conciliation officers.
Yes.
Charged with the duty of mediating and promoting the settlement of industrial dispute. Number 2, conciliation officer may be appointed for a specified area or for a specified industries in a specified area or for one or more specified industries either permanently or for limited period. This is not very relevant. The area of operation. Now, if your lordship come to section 12, your lordship will find these functions.
Section 12. Yes, page 48. At the bottom.
Yes. Duties of the conservation officers. Conservation officer is appointed under section 4.
Yes, yes,
And their duty has been described in section 12.
yes,
So his duty is to try for negotiating, try to bring a settlement
yes.
between employer and employee. And for that purpose, what he has to be done, that has been incorporated. Where any industrial dispute exists or is apprehended, I shall come to the definition of industrial dispute later on. Where any industrial dispute exists or is apprehended, the conciliation officer may, where the dispute relates to a public utility service. Public, there are some services which are called as public utility service. Say, for example, ONGC, Oil India, refinery, all this is public utility service, and a notice under section 22 has been an electricity board also public utility. Notice under section 12 has been given shall hold the conciliation proceeding in prescribed manner. Let us keep it up. Number 2, the conciliation officer shall, for the purpose of bringing about a settlement of dispute without delay, investigate the duties and all matters affecting the merits and right settlement thereof, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement for the purpose. His duty is to settle the issue, to make some endeavor so that the dispute may be settled, not to adjudicate anything. If a settlement or of the dispute or any of the matters in the dispute is arrived at in course of the conciliation proceeding, the conciliation officer shall send a report thereof to the appropriate government or other authorized officer in his behalf by the appropriate government, together with the memorandum of the settlement signed by the parties to the dispute. If it is settled, then he will send a report to the government. And next, if no such settlement is arrived at the conciliation officer, the conciliation officer shall, as soon as practicable, after the close of the investigation, send the appropriate government a full report setting forth the steps taken by him for ascertaining the facts and circumstances relating to the dispute and for bringing about a settlement thereof, together with a full statement of such facts and the circumstances and the reasons for on account of which, in his open opinion, the settlement could not be arrived at. Now, if no settlement could arrive at, then he will submit a report to the appropriate government. Now, for the time being, let us come to the section 10. Section 10.
Yes.
Section 10.
Page 34.
Page
34.
page 30. Now, when the appropriate government will receive a report from the conciliation officer, what he shall do? That has been stated in section 10. Where the appropriate government is of opinion that an industrial dispute exists or is apprehended. When there is no settlement, then industrial dispute will exist. If the dispute could not be a settlement, apprehended, it may at any time by order in writing, number A, refer the dispute to a board for promoting a settlement thereof. We are not concerned with the board. Refer to any matter appearing to be connected with the relevant or relevant to the dispute to a court of inquiry. We are also not concerned. Now C and D are important. Refer a dispute or any matter appearing to be connected with the relevant to the dispute if it relates any matter specified in the second schedule to a labor code. If the issue is any matter, then which is inscribed in second schedule, then it will send it to the labor court. Then refer the dispute to any matter appearing to be connected with the relevant to the dispute, whether it relates to any matter specified in the second schedule or third schedule, to a tribunal for adjudication. So if it is pertains to second schedule or third schedule, then the tribunal can.
But second schedule can also go to a labor court, but
Only-
for the
only
matter
second schedule for-
specified,
Yes.
matter specified there.
For labor court second schedule, but industrial tribunal can adjudicate any matter which is inscribed in second schedule as well as the third schedule. Now your lordship just come to subsection 5 of section 12. It is up to the appropriate government may refer it.
Hmm.
May go. You got it? Subsection 5 of section 12
Yes,
for page 49. If on the consideration of the report, that report that will be submitted by
Yes.
the consultation officer under subsection 4, and the appropriate government shall consider this report. If on the consideration of the report to the subsection 4, the appropriate government is satisfied there is a case for reference. That reference has to be made under section 10. Reference to a board, labor court, tribunal, or national tribunal, it may make such reference. Where the appropriate government does not make such reference, it shall record and communicate the parties concerned its reason there. It is the basic scheme and nothing else. Now, what it transpired to me, probably the labor inspector.
now one thing is, you see, prior to it being referred to a labor court or a tribunal, their conciliation proceedings are done
Yes.
in some cases.
Generally, the conciliation proceeding is required. Sometime, of course,
It is required. Now out here, how do the conciliation proceedings start? Complaint is initiated to the government and the government submits it, or how does it, how does that?
conciliation proceeding starts to a complaint made to the labor inspector.
Labor inspector.
Labor inspector or assistant labor commissioner or the conciliation officer.
So if that is the case, there was a complaint made here to the conciliation officer.
Yes,
So there was nothing wrong.
no. But conciliation officer exercises his power under the Payment of Wages Act, which he can. That is the problem, nothing else. And if
But
your
then,
lordship- your lordship can make it,
huh?
your lordship may pass an order that.
No, but then,
He has the power to conciliation, to hold a conciliation proceeding under section 12. And so mere wrong citing of a section will not debar his power. That your lordship can make it.
yes, what is the power used by him?
That your lordship will find at page 13.
Yes. So it appears at the end of the day that he as a
Wrongly
conciliation, he exercised his power, but he mentioned the wrong provision of law.
That may be, that way your lordship can be forgotten. Okay.
So you mean Payment of Wages Act, but conciliation can be done for issues
Conciliation can
under,
be done.
it can be done under Payment of Wages Act also. So what is wrong?
No, it is a dispute. I owe some money from my employer. The employer has not paid to me. So it will be a dispute. Your lordship goes through provision of section 2K.
2K of the Payment of Wages Act.
No, industrial dispute. It is a dispute.
Yes.
2K. Probably it is page 10, probably. Oh, 2K, page 9. Industrial dispute means any dispute or defiance between the employers and employers, which is not the case of employers and employers, or between the employer and the workman. This is the case, employer and the workman. Or between the workman and workman, we are not concerned with this issue, which is connected with the employment, non-employment, or the terms of employment. So it is connected with the terms of employment.
So now, but what is wrong with this order? I don't understand.
Now,
You see, because here, he is not deciding, he's not adjudicating. He has not adjudicated. He has only uh, made a conciliation. The conciliation has been made between the parties.
he has not stated so much. That is
That is
the
the problem.
he has not exercised his power under section 12 of the Industrial Dispute Act.
He has said that will be recovered from the bills payable to the contract.
He has exercised his power under section 15(3), which he has not.
53.
Section 15(3) of the Payment of Wages Act.
Now let us see what you see out here. Who were there during this conciliation proceedings? No, wait, let me see 53. 53.
Section 15(3).
15.3.
He has the power to conciliate the matter and to bring a settlement. And probably might have been a settlement, probably. Might have brought a settlement. Any application under subsection 2 is entertained, the authority shall hear.
Well, you were part of this conciliation also?
Actually, we were also called upon.
You were there or not?
We are there. But our case is that we have not agreed upon, but the conciliation officer has stated that we have.
That is the thing. That is the thing that that is the different thing.
And our lawyer has also. I leave it to your lordship. Now, your lordship, come to page 15.
No, yes, page 15, yes.
Minutes of joint inquiry and negotiation over the issue of non-payment of earned wage material. Attending the parties, brief case, terms of settlement. Terms of settlement. He has that power to me. Yes.
However, in the discussion, the representative of the principal employer, Bharat Heavy Electricals, has committed to make responsible for payment of the above claims entitled by the workers an amount of rupees so and so to the workers in conformity with section 21(4) of the Contract Labor so and so Act.
Yes.
And also committed that payment will be made to the workers within 1 month from the date of signing of this terms of settlement agreement of the minutes of discussion. And it is also agreed by and between the parties that the entire amount paid to the workers as earned wages and other benefits will be recovered from the bills payable to the contractor so and so, complying with the above mentioned, appreciating the terms of settlement agreement arrived between the representing the management of Bharat Electrical and Swamina International Limited. The workers that so you have agreed, it is agreed. No,
Does it come to page 17? Page 17.
Yes.
That is the legal notice period. Alleged inquiry by the labor inspector cum conciliation officer Congratulations. Bharat Heavy Electrical, no detail. We write to you under such and such instruction of our client, such and such. So we understand that a joint meeting held at the office of the Labor Inspector cum Conservation Officer Kokrajat on 17/10/2013. You have inter alia agreed to pay aggregate sum of rupees 1,91,900 as a compensation to see such and such, such and such, such and such. We are under instruction of our client to like to place on the record that our client is not at all liable to pay any compensation to the state such and such, such and such, such and such. And thus, any payment made by your good office as promised before the conciliation officer shall be at your own risk and paid, and our client shall not accept any adjustment from the amount payable to our client in connection with the same PRPL project. This is our thing.
No, you see, I understand now. The thing is that what you're trying to say is that you had not agreed to
Yes.
the settlement. But despite having said that, it was still recorded as per settlement. You have signed it. Anyway, as per I think one decision of the Supreme Court, it talks about court, not about any conciliation officer or anything.
This is a
But when you say that something has not been recorded, what you have stated has not been recorded, but something else has been recorded, then the
Pardon lies on me.
no, then the only avenue open is to file a review against that said to the said authority and say that we have wrongly recorded this. This is wrong because what has happened before that person, only that person will know. We do not know what has happened between you and those other persons before the conciliation officer. So you have got to file a review before that person concerned, and then you take it up. I don't think we can now say that no, what you said there was something else or correct. We do not know. We were not there. So what to do? Are you withdraw or what?
No, you have to pass a revision order.
Written order.
Revision order. What is the problem with you? You already passed a revision order to the effect that the conciliation officer was of the view that it is a conciliation proceeding and he has exercised his power under section 12 of the Industrial Dispute Act, though he has wrongly quoted his power under section 15 of the,
So what if he has mentioned 15? How does it matter?
though he has.
No, why should I say though?
Because
No.
15, if he has to exercise power under section 15, he is not competent.
But once you have waived your,
Only labor commissioner, deputy labor commissioner, labor court.
if you have waived your right to object on his jurisdiction,
No.
can you,
That
can there be a waiver of
No.
jurisdiction?
Jurisdiction.
Huh?
Jurisdiction cannot.
Why not?
Because there is a lot of judgment.
No,
So, but-
supposing you have waived your right,
No, we can waive my right for that purpose. Jurisdiction cannot be conferred by the agreement. So your
when any application is entertained, the authority shall hear the applicant. And the
No
authority
statutory
of the
body
person.
conferred with the jurisdiction through
But
agreement.
where does it say out here that he's done it under 15.3? He has not said anything.
Yes,
It's only the other, he says out here that action will be taken against you under section 15.3. He does not say anywhere that this agreement has been made under section 15.3.
Yes, a proceedings have been done under section 15.
No, that is, he says that if you do not come, he says that you are hereby requested to attend this office along with so and so, failing which necessary legal action will be initiated against you under section 15.3. But then you have gone there and you have agreed to the terms and conditions. Where is the question of applying 15.3? 15.3 has not been applied at all.
Yes. I'll be clear.
Third Minister A. Das Gupta, learned senior counsel for the petitioner, assisted by Ms. B. Das. also heard Miss Hughes as appearing for
Number one.
respondent number one.
He is my favor. So far, he is like.
If suppose any dispute arises, then Madam Leopard Court. And since your lordship has said, without the notice, when it is stated, any action will be initiated.
Yeah.
Since they have already attended the.
So there's no
conciliation
action
proceeding,
initiated.
So that future action was not never, Madam, that was never happened, Madam.
Correct.
Not.
So, right. This petition has been filed for setting aside the conciliation proceedings made by the labor inspector cum conciliation officer for Praja on 17/10/2013 between the petitioner, MS Bharat Heavy Electricals Limited and the three workmen who and the three and the respondents number
Four,
4,
five,
5
and
and 6. The petitioners council submits that the
We are sitting our paragraph 13 also.
paragraph 13.
No, we are sitting in our. It is like paragraph 13. The petitioner makes to state.
That's right. By this conciliation proceedings. A conciliation order. Is a conciliation order? What is it called?
It should be conciliation settlement.
By the conciliation settlement
It should be settlement.
dated 17/10/2013 issued by the labor inspector cum conciliation officer, Pokraja. The claim of the respondents number 4, 5 and 6 for payment of their dues from the petitioner was realized from the respondent number no, from Bharat Heavy Electricals.
Bharat Heavy Electrical will pay the amount. And they will recover it
From MS Bharat Heavy Electricals,
and they will realize it from us,
which was to be realized
from the petition.
from the petition. So the said conciliation settlement had been made with the agreement of the petitioner, Bharat Heavy Electricals, and the respondents number 4, 5 and 6.
Your lordship will find that page 16, the bottom portion,
Yes.
the parties signing this agreement are legally bound to abide by the terms.
Correct. So stop. Next paragraph. The petitioner's counsel submits that though the conciliation officer has recorded that the petitioner had agreed to the terms of settlement in the conciliation settlement dated 17/10/2013, the petitioner had actually not agreed to the settlement. So stop.
Page
For
17.
recovering the amount paid by MS Bharat Heavy Electricals Limited from the petition. He also submits that the conciliation officer had assumed the power provided under section 15 bracket 3 of the Payment of Wages Act 1936, which could only be exercised by a labor court. That's all.
No, level, no, the other, you should make it clear. Subsection 1 of section 15. It will be better.
Just say 15 only. Just say 15. That's all. 15.
But
On
what
the
the
labor.
person, the commissioner, these are the parties.
15. Just say section 15 of the this one.
Subsection 1 of section 15.
No, how does it matter? You said 15. That's all. Anything else? Miss Yudas, the learned counsel for the respondent number 1, submits that.
We can file the affidavit.
We have filed the affidavit. Madam. We have-
So,
No,
Lordship,
no,
since
no,
not
no.
going on all these things, Madam. Since not going, Madam.
I am
our
going only on the law.
Law. Yes. So here, since Madam, it is, since that proceeding, have not been initiated under 53, because only failing which they were supposed to initiate under section 53 of payment of.
Submits that the conciliation officer has not exercised the power under section 15(3)
Three
of the Payment of Wages Act. In view of,
And signed
and as can be seen
And-
from the,
No.
as can be seen from the,
From the. Madam,
from a perusal of the
State-
conciliation statement
Madam.
read with the letter dated 10/9/2013 issued to the petitioner by the conciliation officer stating that if he did not attend the office on
29.
23/9/2013, action under section 15(3) of the Payment of Wages Act 1936 would be initiated against the petitioner. That's all.
Yes,
I have heard the learned counsel for the party. The two questions that have to be decided is as to whether the issue of, so as to whether the petitioner had agreed to the settlement, conciliation settlement made on 17/10/2013 before the conciliation officer, made by the conciliation officer. And as to whether the conciliation officer had exercised the provisions of section 15 of the Payment of Wages Act 1936.
Section 12 will be better. Of the industrial dispute act.
No, but your case is that he had exercised section 15. I am going to say I am going to say he exercised section 12.
Yes.
I have heard the learned counsels for the parties. The facts of the case is that Bharat Heavy Electricals Limited had been given the contract work to install plants and machineries to generate electricity. Bharat Heavy Electricals Limited engaged the petitioner for doing the contract work. The respondents number 4, 5, and 6, who are the workmen employed by 5, 6, and 7.
Divided 4, 5, and 6.
4, 5, and 6.
6 and
What have I said? Of the, over the workmen of the respondent number, of the petitioner, submitted a claim for non-payment of dues. Submitted a dispute with regard to non-payment of dues by the petitioner. Full stop. Next para. The conciliation officer informed the petitioner that unless they appeared for negotiation with regard to the complaint made by the respondents number 4, 5, and 6, comma, action would be initiated against the petitioner under section 15(3) of the Payment of Wages Act 1936. Full stop. Next para. Thereafter, negotiations were held. Negotiations and conciliation proceedings were held between MS Bharat Heavy Electricals Limited, comma, the petitioner, and the respondents number 4 to 6. As per the agreement arrived at between the parties, MS Bharat Heavy Electricals Limited was made responsible to pay the claims of the respondents number 4, 5, and 6 amounting to rupees 1,91,900. Full stop. The said amount was then to be recovered by MS Bharat Heavy Electricals Limited from the petition. Full stop. Next paragraph. The operative portion of the conciliation settlement dated 17/10/2013 is reproduced below here and below as follows. Page 15 of the petition. It starts from however, however, and it ends at here, okay, till breaching the same. BREACHING, breaching the same, okay, page 16. A perusal of the above clearly goes to show that the petitioner had agreed to the terms and conditions of payment to be made to the respondents number 4, 5, and 6 by MS Bharat Heavy Electricals Limited, with the subsequent recovery to be made from the bills payable to the petitioner. However, the petitioner has now taken a stand that it had not agreed to the said concession recorded in the conciliation agreement. It is difficult for this court. It is impossible for this court to know as to what had transpired before the conciliation officer and as to who had said what. This court can only go into the issues of fact on the basis of what has been recorded by the conciliation officer. A little help may be taken in an issue of this, in an issue raised by, in an issue raised of this nature by referring to the judgment of the Supreme Court in state of Maharashtra versus Ramdas Srinivas Nayak, reported in 1982, 2 SCC 463, wherein the Supreme Court has held that a judge's record is conclusive and none can contradict it except before the judge himself. Full stop. In the present case, though the conciliation officer is not a judge, the ratio decidendi of the said case can be made applicable to the facts or to the issue raised by the petitioner in this case. Accordingly, this court is of the view that the petitioner would have to approach the conciliation officer again by way of a review petition, if so advised, to ventilate his grievance regarding a recording of a statement regarding of a concession not made by the petition. Next paragraph. With regard to the question of whether the conciliation officer had exercised the power under section 15 of the Payment of Wages Act 1936, this court finds that the same has been this court finds that the conciliation officer has not exercised the power under section 15 of the Payment of Wages Act 1936, but the power of the power provided under section 12 of the Industrial Disputes Act 1947. In view of the reasons stated above, this court does not find any ground to exercise its discretion in the present case. That it petitions accordingly dismissed.
Next item, we can leave it first for the day about anything.
Okay. On the prayer of Ms. A. Das Gupta, Lion Senior Counsel, list the matter after the vacation. Which item? 16.
We have a part and matter.
Okay, no problem. In item 15, what is your stand? What stand? She said that credit petitioner is correct.
Yes.
What is your stand? This is not labor court. Sorry.
Labor Act. Inspector. Labor inspector.
Huh?
Labor inspector.
Yes, right. Miss R.B. Bora appears for respondent number 2 and 3. Okay. Yes, that's all.
Yes, that is better.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner, who submits that the petitioners have been running the Gerua Daily Bazaar since the year 1946 on the land of the
Kolia Gusai Than
Committee, covered by Jamabandi,
covered by land measuring 3 bighas.
Covered by land measuring 3 bighas.
Only. Tag number.
Dag number.
Patta number 64. Tag number.
Patta 64. Dag number.
137. 137.
137. Pustak. The petitioners are aggrieved by the, where is that NIT?
Yes, that is my lord page
15.
are agreed by the notice inviting tender by the notice dated 29/5/2024, whereby a number of bazaar slash ghat slash Meen Mahal are to be settled by the Lahori Ghat Anchalik Panchayat, including the Gewra daily market. The petitioner council submits that the respondent number 3 cannot settle Gewra daily market as it is standing on the land of the huh?
Go with it, Khan.
Han committee.
Yes.
Next, Mr. S. Datta, Learned Counsel for the PNRD, submits that if the Gewra daily market,
Yeah.
daily market is standing on private land, the respondent number 3 will have no authority to settle the market. However, a verification needs to be undertaken by the competent authority to verify whether the said land belongs to the said committee. What committee is that?
My lord, that is not disputed. They have land. The dispute is that market is inside the land or not.
Market is
Within their private land or not.
whatever I said. Whether the market being run by the petitioners is being run within the private land of the petitioner. Next. He submits that the circle officer, which area?
Purgaon Revenue Circle.
Huh?
Puragaon Revenue.
Guragaon Revenue Circle may be directed to have a spot verification and make a report as to whether the Gewra daily market is being run on the land covered by Pata number so and so, Dag number so and so. Huh?
They belong to Kolia Gochai Thanshu. It's number one.
Huh. Next. The petitioner's counsel submits that he has got no objection to the circle officer conducting a spot verification and making a report on the same. Next para. In view of the consent of the parties, the circle officer so and so is directed to cause an inspection, spot verification to ascertain whether the Gewra daily market is being run on land covered by on the 3 bighas of land in Pata number so and so, Dag number so and so, and submit a copy of the same to the respondent number 3 with a copy to be furnished to the petitioners also.
The time frame maybe.
The verification, the report should be made by the circle officer within a period of
15 days.
within a period of 15 days from the date of receipt of a copy of this order. The report, if the report is to the effect that the Gewra daily market is being run on Dag number so and so, Pata number so and so, comma.
But that may be specified in the petitioner's name because Dag is a 13 bighas.
Is in the petitioner's name, in the petitioner's name, or the society, with the petitioner's name, in the petitioner's name, comma, that is,
Kolia Gokai Than.
that is,
Kolia Gokai Than, petition number 1. Petition number 1.
in the name of the Kolia Gosai Than Committee, comma. The respondents shall not act upon the notice dated 29/5/2024, insofar as it relates to Gewra daily market.
Today is fixed, so till.
Full stop. Till a decision is taken by the circle officer concerned, comma, the notice status quo on the Jora daily market as reflected in the notice dated 29/5/2024 shall be kept in abeyance. The writ petition is accordingly disposed of.
My lord, Lordship may direct the petitioner to serve a copy to the circle.
Why don't you serve?
My lord, government advocate is.
Okay. You just right. The writ petitioner shall serve a copy of this order to the circle, to the concerned circle officer, respondent number,
Five,
bracket respondent number 5.
as well as respondent number 3.
Respondent number 3 and respondent number 5 within a period of
Monday, yeah,
within a period of 5 days.
Five.
5 days. A period of 5 days from today.
communicate to the.
I'll communicate.
Mr. S. Datta shall communicate the order passed today to the respondent number 3.
Public.
6 item 22.
So take lordship, including clause 10, lordship.
Hmm?
At page 41. The tender for all Bazar Hut, Parghat Minimahal offering highest value revenue will be considered for settlement. If the tender offering highest value revenue does not include the relevant papers and documents, except port fee and arrest money, EC will be given a period of 3 days for submission of such papers and documents. And if EC fails to submit the papers and documents within the specified period of 3 days, his or her tender will be cancelled and his or her earnest money will remain forfeited. And in such case, the tender of the person offering second highest value revenue will be given the opportunity to take settlement with the state council. This clause 10 was ultimately lordship in writ petition WPC number 6902 of 2021. It starts from page 55 lordship. It was argued
Just a minute.
and page 52.
Yes.
First part is page 64, paragraph 14 lordship. In the context of existence of associated statutory provision and before on the respective submission advanced by the learned counsel for the parties, it's apt to mention that the contents of the learned counsel for the parties have entered around clause 10 of the tender notice on one hand and clause 11 to clause 17 of the tender notice on the other hand. Apart from the notification dated 29/6/2018 and the notification dated 23/4/2021 issued by the government of Assam in the Panchayat rule. Thus, it appeared necessary to have looked at the clause 10 to the and to clause 17 of the tender notice for ready. Relevant para page 20 and 21. After discussing about judgment lordship, page 69. Para 20.
Yes.
In the light of discussion made above, it is clearly emerged that clause 10 is standalone provision and the procedure prescribed herein is incompatible to the other terms and conditions incorporated in the tender clause. Tender notice. Clause 17 of the tender notice has entirely set forth that in the event a bidder does not meet the terms and conditions incorporated in clause 11 to clause 16, the bid would entail rejection. Clause 11 to clause 16 of the tender notice require the bidder to submit a number of documents described herein to accompany the bid. If the procedure indicated in clause 10 is required to be followed as has been contained on behalf of the petitioner, one could also contend that the same would be aberrant of a competitive bidding process as there would not be any fairness, transparency, efficiency, and rationality. One way of interpretation of clause 10 could be that a bidder at the time of submission of his sealed bid in response to the tender notice need not submit any other documents except the prescribed tender from port fee of rupees 8.25 and the earnest money as quoted in the tender notice. If his bid value emerges as the highest, then he would be called by the tendering authority to submit all the other requisite documents. If he manages to submit all the requisite documents within the stipulated period of 3 days, then he becomes the highest credit bidder which he otherwise at the time of submission of bid was not. In the event he failed, then his bid would be rejected at the cost of forfeiture of the earnest money. One could also visualize a situation when about n number of bidders participate in response to the tender notice by submitting only the court fees, terms and earnest money, and after granting opportunity to those n numbers of bidders to submit the documents a period of 3 days. If all of them fail, then by that time a period of n to 3 days will expire, whereas the period of settlement is only for 1 year. If all the bidders who have offered highest bid values are to be given opportunities of meeting the exigencies one after the other, then there would be no requirement of meeting the eligibility criteria by the bidders on the last date of the submission of the bids. There could be many others like situation of all which cannot be envisaged now. From the above, it is certain that if clause 10 of the tender notice is made applicable, then the same would give the benefit of the bidders whose bids were invalid at the time of their submission, and the same would be the prejudice to those bidders whose bids were complained to the terms and conditions of the tender notice at the time of their submission. The issue of acceptance or rejection of a bid of bidder is to be examined not only from the points of view of both the tendering authority and such a bidder, but also from the point of view all other participant bidders.
So was clause 10 set aside?
No, in this, but Lordship, ultimately it was held that the said situation is clearly opposed to the principle of equality and this into Article 14 of the Constitution of India.
No, I'm not on that. So after making all these observations, it was not set aside.
Lordship, but clause 10
That was not an issue.
not it.
Ah,
But subsequently another, wherein the clause 10 was selling, Lordship, I have given the compilation.
yes.
Document number 1. In this case, Lordship,
Yes,
para 3, Lordship.
para 3.
Para 3 is 10.
Yes,
In fact, the opposite principles were laid down by the Honorable Supreme Court about 2 decades earlier in the case of Tata Silver, which would be referred to later in the. With the background of this code is required to consider and determine the issue raised in this branch of petition. In this petition, a common challenge has been made a particular clause of the notice in the tender floated by the concerned for happening. The settlers are pertaining to the district. The principal contents of the petition is that clause 10. Clause in question is in the teeth of Article 14 as it given. So ultimately, in this case, Lordship, the clause 10 was challenged, and Lordship, the relevant paragraphs is case 20 and 23. But 23 is
yes.
having said that the issue is required to be adjudicated so far as petitioners who have submitted their bids in response to the aforesaid NIP are concerned. The challenge is regarding a clause which gives 3 days time to the highest bidder to submit furnished documents in support of the bid as required under the NIP. A minute examination of the said clause would show that such liberty is given to the documents other than the earnest money deposit and court fee. A bid without being accompanied by the court fee and earnest money in any manner cannot be taken into consideration. However, in case other documents which are also necessary to constitute the bid to be valid, 3 days time is given to the bidder whose financial bid is otherwise found to be highest. This court finds force in the context of the learned standing council of the department that the objective is only to ensure that the maximum revenue is fetched in the tender for allotment of the markets, cards, feed, mohol, etc. This court has further noticed that the period granted is limited to 3 days, enabling a highest bidder to furnish the documents which might in a given case not be available or could not be charged at the time of the submission of the bid on the last day. The clause further stipulates that the liberty is not an unlimited one, but only for 3 days, whereafter the term of the second highest bidder could come with the same conditions. Such a clause in the considered opinion of this court cannot be termed of the constitute as unreasonable or arbitrary, and rather the same appears to be in consonance with the principle of fairness and transparency, as a fair opportunity is given to ensure the maximum revenue is earned by the state.
So was this order put to challenge before the
Yes,
division
yes,
bench?
The next documents number 2, it starts from page 20.
Yes. So out here, in this batch of writ petition, the challenge was to clause 10.
Clause 10, but
it has-
someone has not participated in the tender.
By someone not.
Someone has not.
But then what has the court said that cannot be unreasonable arbitrary, appears to be, so it has upheld clause 10.
Thereafter, the division bench, but division bench has not heard not decided that regarding the clause 10. If Lordship have perused the division bench order, Lordship. Page from, start from page 22. Relevant paragraph, page, para 10, 11 and 12. Page 25.
Page 20?
25,
Yeah.
paragraph 10.
Yeah.
From the pleadings made in the requisition and from the impugned order, it is clear that petitioner, without raising any challenge to the offending clause of the NIT, participated in the tender process in respect of two markets in question, and when he became
Without
unsuccessful,
challenging, you said that there was a challenge.
someone has not participated.
The person who did not participate
Yes.
challenged it.
They have challenged.
There are numbers of cases. One of them is this.
When someone
Only
has-
one of them. Only in one there was a challenge.
Yes.
Only in one there was a challenge to clause 10.
Others
And
they
in-
have accepted.
that is- Only in one there was a challenge to clause 10. There also the person who did not participate
Yes.
challenged it.
He filed that appeal.
Yes.
If I
There is another process in respect of two markets in Gaza, and when he become unsuccessful, turn around and challenge the clause 10 of the tender. The law is well settled that when a tenderer participated in the tender process without objection and subsequently found to be not successful, its challenge to the process of is precluded. Such a tenderer cannot be allowed to turn around and contend that the process was unfair by the virtue of the existence of a clause in the NIT. This court cannot also find fault with the decision of the learned.
where are you reading?
Case
Para?
20,
Para?
Para now 11.
Huh?
Para now 11. Case 26. Clear. Paragraph.
Just a minute. Read from para 4.
The aforesaid offending clause then empowers the settling authority to settle a cart, etc. with the highest bidder, even if the highest bidder had not submitted necessary documents, except court fee and earnest money subject to the highest bidder furnishing such necessary documents within 3 days time from election. The offending clause was challenged primarily on the ground that it violates the principle of equality as invested under the Article 14 of the Constitution of India. It was a further ground that a learner single judge dealing with a challenge to a similar clause in a similar NIT issued by the same authority held in its judgment dated so that clause then is made applicable, then the same would be for the benefit of the bidders whose bids were invalid at the time of their submission, and the same would be for the prejudice to those bidders whose bids were complained to the terms and conditions of the tender notice at the time of their submission. Such a situation is opposed to the principle of equality and in Article 14 of the Constitution of India, and same would clearly be discriminatory and same would be unjust to a bidder who is otherwise a very bidder in terms of Rule 4710 of the Assam Panchayat Financial Rules 2002. As many as 5 requisitions were filed on a similar ground assailing the offending tender clause. Pursuant to the NIT, the requisition submitted bids in respect of two markets. So it is an admitted fact the petitioner was placed at 13th position in terms of the bid price offered in respect to the state market against the highest bid of the The learned signatures have declined to examine the issue raised by the present appellant requisition for the reason that even if such issue raised are answered in favor of the petitioner, the same is not going to have any effect whatever to the petition. The learned counsel for the appellant basically assessed the judgment of the learned signatures on the ground that learned signatures, while deciding the issue raised, had failed to consider the ratio laid down in hospitality and did not entertain such a challenge clause than relying on the judgment of the Honorable Apex Court in Michigan, so and the help that no malafide or favoritism has been made out as the offending clause is a general one. From the pleadings made in the requisition and from the impugned order, it is clear that petitioner, without raising any challenge to the offending clause of the NIT, participated in the tender process in respect of two markets in question, and when he became unsuccessful, turn around and challenge the clause 10 of the tender. This law is well settled that when a tenderer participated in the tender process without objection and subsequently found to be not successful, a challenge to the process is precluded. Such a tenderer cannot be allowed to turn around and contend that the process was unfair by the virtue of existence of a clause in the NIT. This court cannot also find fault with the decision of the learned singular in not entering the requisition preferred by the appellant for the reason that the issue raised by the petitioner, even if answered in his favor, same will have no effect on him inasmuch as this code is the total agreement which such due in the given facts of the present case. So far, relating to the issue that there are two divergent views by the two learned single judges in respect to the validity of the offending clause, that this code is not inclined to entertain such an issue at the behest of the present affiliate for the reason discussed here and above, and the same may be dealt with and in an appropriate case if necessary arises. So in this case, Lordship, division bench has not decided the clause 10. issue of clause because they are not participating in the process. So, Lordship, another judgment, Lordship, I am relying by this honorable court. Where the several learned single judge who has appealed the clause 10, Lordship.
Taking a U-turn.
Lordship. Para 20, Lordship, in this case is. Page 36. In this case, the NIT was challenged, Lordship, area issued by the All India Limited. And the learned single judge has, while deciding the issue, has dealt that when the eligibility clause is up to the eligibility will be fixed on the last date of the tender submission. It is a settled law.
Huh?
Lordship, make peruse the page 20. Page 36. Page 36
Page 36
of
of
the
the
document.
good. Yes,
To examine the first issue, certain dates would be crucial. The last date for the submission of the bids was 4/8/2002, on which date the petitioner had actually submitted his bid. The date on which the special resolution of the petitioner company by to incorporate the clause pertaining to the nature of work in the present case was approved by the register of company only on 18/11/2022. The settled position of the law is that the eligibility qualification has to be there on the last date of submission of bid. Any such eligibility or qualification obtained after the last date of the submission cannot be taken into consideration inasmuch as the same will open to floodgate. And this, we have placed these two judgment, Lordship, earlier also, last year also, the same clause was incorporated and the petitioner had challenged the same before the learned single judge. And the learned single judge, after hearing those, after going through the both the judgment, Lordship, restrain the respondent authorities from giving effect to the clause 10, and therefore received the arguments was advanced by the counsel for the respondents, that is obiter dicta, and that was also dealt by the learned single judge. Lordship, we have annexed the case,
That was withdrawn, my lord, thereafter.
but
That is not a.
That was our-
option.
page 74.
Page?
Page 74.
Oh, the writ petition.
Writ petition. Page 78.
yes.
Paragraph 11. Considering the rival submission made in the matter, it is observed that in the proceeding of WBC number 6902 of 2021, the validity of the clause 10 of the NIT was not under challenge because as per the facts of the said case, the bid of the petitioner hearing was not complained and therefore the petitioner hearing sought to evoke clause 10 of the NIT so as to impress upon the court that he should be given an opportunity to produce furnish additional documents to make his bid valid. Under the said circumstance, this court by an elaborate discussion has held that the clause 10 was discriminatory and therefore the interpretation sought to be given on clause 10 of the NIT by the petitioner in WC Soido was not accepted by this court by refusing to give liberty to the petitioner under clause 10 of the NIT to produce documents. Accordingly, the petition was found lacking merit and the same was dismissed. Therefore, the court is unable to accept the contents of the learned additional advocate general for the state that unless the validity of the clause 10 under challenge observation by this court on clause 10 of the NIT in person should be considered only as obiter. In the case of Arun Kumar Agarwala versus State of Madhya Pradesh, the Supreme Court of India has extracted the meaning of word dicta for various authorities. Paragraph 21 thereof is quoted below. So at the stage, it is petitioner to consider the nature and scope of a mere observation or obiter dicta in the order of the court. The expression obiter dicta or dicta has been discussed in American jurisprudence so. Ordinarily, a court will decide only the question necessary for determining the particular case presented. But once a court acquires jurisdiction, all material questions are open for its decision. It may properly decided all questions so involved, even though it is not absolutely essential to the result that all should be decided. It may be instance determine the question of the constitutionality of a statute, although it is not absolutely necessary to the disposition of the case if the issue of constitutionality is involved in the suit and its settlement is the public importance. An expression in an opinion which is not necessary to support the decision reached by the court is dictum or obiter dictum.
dictum or obiter dictum is distinguished from the holding the court in that so-called law of the case does not extend to mere dicta, and mere dicta or not binding under the doctrine of state issues. As applied to a particular opinion, the question of whether or not a certain part thereof is or not a mere dictum is sometimes a matter of argument. And while the terms dictum and obiter dictum are generally used synonymously with regard to expression in an opinion which are not necessary to support the decision in connection with the doctrine of stare decision. So,
Anyway, so
so this court
now what happens, supposing now your challenge was on two grounds. One is on clause 10 and one is that time, not time, not
45
time.
days.
45 days not
only
given.
21 days given, although 31 days, but from 30.
Okay, we'll give you another few days, but the one thing is that, one issue is this. Supposing this court were to hold that clause 10 has to be set aside. Suppose it sets aside, then what happens to those persons who did not submit?
Last occasion also, when the dishonorable court has sustained that they have issued a provisional approach and thereby they have
They should allow also to correct, just in case.
yes,
Those persons who have submitted their bids, they should be allowed to make, they should be allowed to submit a subsequent bid or an additional bid or whatever, I don't know what you call it.
so otherwise.
May I pray something, my lord? Lordship may at this stage notice may be issued, my lord.
Yes.
And Lordship may grant some more time to all the petitioners, my lord. And thereafter Lordship will examine whether clause 10 is valid or not.
Yes.
While our detailed
Every year, Lordship, it will come.
No, but yes, that will have to examine. We cannot decide
Because,
straight away.
yes, continuously it's third year, my lord. Either they will not succeed, they will withdraw, or my lord, after 1 year, it will be becoming success.
Okay, right.
But this is notice may be only issued, my lord.
Right, Mr.
K. Kolita.
K. Kalita Learned Counsel for the petitioner who submits that clause 10 of the NIT dated 30/5/2024 should be set aside as the same is in violation of Article 14 of the Constitution and 14 of the Constitution. First one. In this regard, he has relied upon the judgment and order dated. Which para?
20 and 21 of
20 and 21 of the judgment and order dated
17/5/2022.
17/5/22 passed by this court in WPC number 6902/2021. He further submits that in terms of Rule 47(2) of the Assam Panchayat Financial that was rules 2002, 45 days have to be given to the tenderer for submission of his bids. However, in the present case, the NIT was issued on 30/06/2024 and 35/2024. And the last date for submission of bids was 36.
21.
Huh?
Tomorrow.
21
Yes, sir.
or 21. 21/6/2020. So how much more days should we give?
My lord, the settlement has to be made from 1 mile, past July, before date, my lord.
Till 30th?
Yes, that can be done.
30th is Sunday, what?
30 is Sunday, 29.
29. Rule 47(2) of the Assam Panchayat Financial Rules 2002 states as follows. A reading of the same shows that shows that a tender notice has to be floated at least 45 days before the last date of the panchayat financial year. And where is that 1st July you said? Where is that?
The act. 105.
While section 105 of the Assam Panchayat Act 1994 provides that settlement of huts by the Anchalik Panchayat
In the definition, it is written, my lord.
Huh?
In the definition, my lord, section 2.
Why you are reading 105?
105 is saying that it's a financial panchayat year.
Where does it say that?
Yes, 105, my lord. The settlement of huts by Anchalik
Ah,
panchayat. All the huts within the
states that the period of settlement shall not exceed one panchayat year, which is from 1st July to 30 June
June 2000.
of the subsequent year. So, in the present case, it is clear that there is no question of compliance with section 47(2), in as much as there is only 11 days left for the month of June to end. Full stop. However, in view of the fact that the NIT has only provided for 20 days for submission of tenders, this court is of the view that the what is that respondent number? Anchalik Panchayat. The respondent number 4. Who has issued the NIT?
Jointly issued, my lord.
4 and 5.
The
4 and 5.
the NIT issued by the respondent number 4 and 5. No, the last date for submission of bids in person to the NIT should be extended till 29/6/2024 to enable the petitioner and all other persons to participate in the settlement process. Full stop. Next paragraph. The second, with regard to, no, first stop. Further, in view of the challenge made to clause 10 of the NIT, this court is of the view that a corrigendum should be issued by the respondent authorities informing the tenderer that clause 10 has been put to challenge and that the last date of submitting tender document has been extended up to 29/6/2024. Now, what about the thing?
Say I have some objection, my lord.
Lordship, earlier Lordship, page 83, Lordship.
You see, now let us see the NIT.
Right.
Page
Page Lordship, start from page 13.
39.
Clause 10 is at 41.
Huh?
Clause 10
41 is the clause 10.
If we use the clause 11 to clause 16. These are the documents which are required to be submitted along with a bid document. And clause 17 prescribes that the tender will be cancelled if the condition of column number 1 to 16 of the part 1 and part 2 are not fulfilled.
Next, right. clause 10 provides that if the tenderer offering the highest value has not enclosed relevant papers and documents, he will be given a period of 3 days to rectify the said error. So on the other hand, clause 17 of the NIT provides that the tender will be cancelled if the condition numbers 1 to 16 of part 1 and 2 are not fulfilled. Part 1 and 2 provides for the various documents to be submitted by the petition. There seems to be a conflict between clause 10 and 17 of the NIT.
May I submit on this matter? If I can satisfy your lordship. Lordship, if 1 to 16 will not submit, then the bidder will be defective. That is admitted.
But if he's
We
the
are,
highest,
we are giving clause 10, my lord. We are giving opportunity to all the bidders to clear his defect. Without.
no, clause 10, you're giving only to the highest bidder.
Highest bidder, my lord, only after opening of the bid, my lord.
Correct.
Only after opening of the bid.
Right. On considering the above,
My objection might be recorded.
the Mr. L. Data submits that there is no conflict with clause 10 and 17 of the NIT, in as much as if there is a defect in the tender document of the highest bidder by not submitting important documents, 3 days time is given to the highest bidder,
Only after opening of the bid, my lord,
only after opening of the bid.
because. after
Naturally,
opening,
it
my
has to
lord-
be only after, it cannot be well closed. How will you know?
My lord, after opening, my lord, that article 14, they cannot claim that we are all are under article 14, because highest bidder will be given opportunity only.
No, right. Next, on considering, what have I said? On considering the conflict between clause 10 and 13, and the fact that only the highest bidder is to be given a concession in violation of clause 17 of the NIT, this court is of the view that that as an interim measure, clause 10 of the NIT shall not be acted upon.
My lord, that part may be also recorded, my lord, that earlier judgment, that was clause 10 was not challenged in that matter, but subsequently clause 10 was challenged, and that was allowed by the Supreme Court.
You do it wherever.
Because-
I cannot write everything that you all want.
If lordship, my lord, if department will say that you go to appeal, then court division bench will say, my lord, that you did not argue that points, my lord. That is what
Okay, they just said before that, they just write,
I'm honestly submitting.
that's right. In the judgment and in para 20 and 21 of the judgment and order dated 17/5/22 passed in WPC 6902/2021. A coordinate bench had held that clause 10 was opposed to the principle of equality enshrined in Article 14 of the Constitution, in as much as a relaxation has been given only to the highest bidder, while on the same ground, tenders can be disqualified if they are not the highest bidder. Full stop. That's correct. Then next. In the judgment and order dated 23/11/22, passed by another coordinate bench in a bunch of writ petitions involving WPC 4377/2022 and others. Comma. It was held where para?
There are 23.
It was held in para 23. That clause 10 cannot be termed or constituted to be unreasonable or arbitrary, and rather appeared to be in consonance with the principles of fairness and transparency, as a fair opportunity was given to ensure that maximum revenue was earned by the state. Pusta. In the bunch of writ petitions that was decided by judgment and order dated 23/11/22, the challenge to clause 10 had been made by a writ petitioner who had not participated in the tender process. Pusta.
There are different petitioners. One of them was not.
Okay, okay. Don't say that, then cut that. Cut that last sentence, huh? Pusta. The division bench in its judgment dated 31/5/23, passed in WA 395/2022. Pertaining to the judgment and order dated 23/11/22, passed in the bunch of writ petitioners, including WPC 4377/2022, has held in para 12 as follows. So far relating to the issue that there are two divergent views by two learned single judge in respect of the validity of the offending clause 10, this court is not inclined to entertain such an issue at the behest of the present appellant for the reasons discussed herein above, and the same may be dealt with in an appropriate case, if necessity arises. As such, the issue with regard to the challenge to clause 10 is still an open-ended issue. Correct? Next. In the case of ASC Consulting Private Limited versus Oil India Limited and 10 others, WPC 1061/2023, which was disposed of by judgment and order dated 28/4/23. A coordinate bench had held that the settled position of law is that the eligibility/qualification has to be there on the last date of submission of bid. Full stop. Any such eligibility or qualification obtained after the last date of submission cannot be taken into consideration inasmuch as, the same will open a floodgate. considering all the aspects, and that's the same thing, then just, I'll put it wherever it is.
High level.
This the matter after when?
After 30th June, my lord.
30th June.
Sorry.
Suddenly you're in no hurry.
17. Because if they are not succeed, that will become infructuous again. This case.
This is the matter on 17th June,
17.
July.
17 July.
Oh, why not next week? I thought till
Lordship is extending the time.
17th June.
How like that?
And we had a board.
Lordship, if Lordship recollects the facts, in this case, the rate quoted by the bidder, it should not be less than, Lord, the language used is, if Lordship to kindly come to page 177. It's basically a transport contract. Page 177.
Yes,
C to 2 milord.
C2.
Yes, last one, bidder to note, as a Lordship.
Yes.
Bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rate declared by IOC for Sibsagar as on TBO means tender bid opening date. Now, my lord, in the earlier tenders, if your lordship will kindly come to page number 242. Rather at page 254. This was a tender of 2015. Please come to page 254. First sub-para on top. Bidder to note, as a lordship.
Yes.
Bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.25 into diesel rate as on 36/19. That is, so rate was given 65.18. Now, if the lordship would kindly come to 262. That is a tender of 2019. 262. That bold portion somewhere in the middle. Bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.25 into diesel rate as on 36/20. That is 79.80. In the present tender, the rate is not given. Now, so in the absence of the, rate specified in the tender, we access the Google, and what we got was at is page 236.
Yes.
So diesel price in Sibsagar, this is what we got from Google. Diesel price today, Sibsagar, Assam is 89.49 liter. No change was required. Anyway, this is not important. So I quoted 89.49. It so turned out that on that particular day, the diesel price rate in Sibsagar town was different in different oil depots. For example, if you would kindly come to the next page, 237. Damani service station is okay, 89.49. Then Milord will kindly come to 239. This is Lohit fuel service. It is 89.16.
Then Milord will kindly come to page 240. 89.17. Now, in view of this, Milord, there was correspondence between ONGC, the employer, and the IOCL. Is it possible for the members of public to know what is the rate of IOCL? In fact, there was a meeting where this aspect was discussed. Now, for that, may I have your lordship's kind attention to page number 375.
No, so that is why I think we had asked the
Now,
IOCL.
yes, I was coming to that. Peter. Now, this is very important in this case. Kindly have this page 375. It's an affidavit in reply filed by us, where we have referred to one, mail, my lord, wherein, my lord, there is a reference to a discussion where the authority, ONGC authority itself wanted to know whether it is available in public domain. Otherwise, we are insisting on a condition. Unless it is in the public domain, how does one know? Or best, you should have given the rate, then this problem would not have arisen as you have done earlier. Non-giving has led to all these problems. Now, please come to 375. Now, this is one Kumud Hazarika of ONGCL. He is writing to one Mr. Kumar Anuj. Kindly see, I'm reading the content. In the price format of the subject tender, the following note is present. Reader to note that the basic quoted running rate per kilometer exclusive of GST should not be less than so and so. Rate declared by IOCL Sibsagar as on the technical bid opening date. Reader should quote the running rate per kilometer based on HSD rate declared by IOCL for Sibsagar as on the technical bid opening date. If the basic running rate are quoted less than the basic running rate per tanker, such bid shall be rejected. Now, this is important. Page 376. As per the discussion held in the tender committee meeting on 11/9/23, indenter is requested to get the confirmation information from authorized representative of IOCL that whether IOCL declares their HSD rate for Sibsagar in the public domain, like on their official website or internet on daily basis or not. It was the concern of the ONGC tendering authority that since we are insisting on the particular requirement, first let us get the confirmation from the IOCL whether this is available in public domain. Further, in case they confirm that they update their HSD rate for Sibsagar on daily basis on their official website, kindly obtain the uniform resource locator of the said website. URL is, my lord, uniform resource locator. Now, this exercise, which was proposed, was never taken with logically. Now, eventually, my lord, pursuant to your lordship's order, IOCL has filed an affidavit wherein they have said it is available. But I'll show, my lords, I have filed an reply to that. If your lordship should kindly come to page number 436. Sorry, 426. This is our reply to the affidavit filed by IOCL. Now, when we access the app, my lord, this is how it proceeds. Indian Oil, one mobile app. Then it goes on. Then please come to page number 431. After following, my lord, different directions, we reach this page 431, where either we have to sign up or to log in. Other lordships got it. Page 431.
31. Yes.
Chronologically, my lord, this is how it proceeds. Then please come to the next page. We are supposed to upload our mobile number or email number or password. Then my lord will kindly come to the next page. Register to Indian Oil one account, mobile number ED so and so so and so. Then we have to agree. Now it results in registration of the applicant's name and it does not proceed further.
So you try it with your phone.
No, my lord, I think IOCL can explain this.
No, let us see if what you're saying is correct. You tried with your phone now. All three of you.
Yes. Come to my hand. You can
No, you try it also. Let Mr. MK Chaudhary try it. If you can, if it goes through, well enough.
It is available.
Please, see.
This morning also I tried one. The network here is weak, but then my lord, I got this here.
in Sipsagar.
Sipsagar.
Any place.
No, try Sipsagar.
Sipsagar, I tried Guwahati.
No.
No,
Sipsagar.
this
One
one
is
about-
available. We also know.
Sipsagar, you gotta try Sipsagar. Once.
In High Court, it's a fact, my lord, network is very bad. But I think we should have the Wi-Fi facility.
It works, my lord.
In the bar rooms.
You're having a bathroom. I don't even have in my room.
No, nobody has. No, we don't have, my lord. We don't have.
For speaking on the mobile itself, I have to go out right to
All
the
right.
end.
Right.
Right, end of the corridor.
Veranda and all.
From the bar, I have to call it.
Ah.
And also from officer in the he made me say that everything is now being connected by van and that work is being done that will take some time, maybe in a couple of weeks.
Okay.
So we connecting I have old building also.
Okay, very good.
So maybe for a couple of weeks.
But otherwise, nowadays, without, Wi-Fi, it's very difficult.
Very good.
My lord, in fact, my lord, if that page 430, use current location. My lord, location name is to be given, then we have come.
No,
You just try in your phone.
No.
Yeah, I have,
This
my lord,
stage we have
Sipsagar.
No,
Let's try.
my lord, here net, my lord, very slow.
Then what to
That
do?
is-
How do
here-
we prove?
Guwahati I am getting,
This is
yes,
a question of fact. How do we
Yeah.
prove?
because they have found it, my lord.
No, he has found Guwahati. He has not found
No.
Sipsagar. Here. No, we don't want Guwahati. We want Sipsagar.
Here I have tried my this location here today and then it's
Have you tried Sipsagar ever?
No, my lord.
And you've got Sipsagar.
No, my lord. It's very simple. Question is, we have also tried on several occasions. This is where it ends. It ends with registration.
Yes, show them. Hey, show them. Come with the petitioners.
And all the,
Sipsagar.
In fact, my lord, they also knew about it. If you will also see,
No, maybe the clients knew. Lawyers too were slightly,
yes.
lawyers are not a
No,
spring chicken anymore. No?
The petitioner, my lord,
So,
petitioner who filed 2 tenders, in one tender he had correctly placed.
huh?
Petitioner filed 2 tenders.
Okay.
My lord, at page 262, if you will also see, and another is, my lord, I just saying for at page 340, if you also see both the, my lord, the pages, then you'll also find that this is it knowingly, my lord, we have given higher there.
No, 340 for Sipsagar.
Yes, my lord, for 600, my lord, no, he had filed 2 tenders for the same, my lord, yeah. Page 282, it is opened on 26/9/2023. Page 2.
My lord, there is one difficulty.
282, my lord, you'll also get.
My lord, now the rates are different.
What do you mean? There is a difference.
It's not uniform for Sipsagar.
Acha.
That's what happened in our case. That's why we said there are 3 branches. So what prevents you from giving a basic rate? Ends of the issue.
And you give you 2 different rates. What?
Yes, that's now I have shown to my friend 3 different rates in 3 outlets in Sipsagar. somewhere it is, 97.60, somewhere it is 90.48. Different rates.
No, no, now you show it to Mr.
It's a-
You show it to Mr. Sehwal also.
Itu তোমার itu location মারিস না itu sama. Wah. Itu again.
If it was your kids doing the within 2 seconds, they would have got it out. But they have got to show.
Swa. 90.26.
With
60. Beleg বের করো না?
But Malad, your losses may just see 282 and 340 base. 282 and 340.
Milord,
282, Malad, your
Yes.
losses may see.
এখন কেতিয়া? My lord, the same position happened. I'm sorry.
282, yes.
282.
Yes.
Petitioner is, my lord, item 6,
Mahmood Ali.
Mahmood Ali.
Yes.
This is, the bid opening is 26/9/23, my lord.
For which area?
But same,
Same Sipsagar.
same Sipsagar, my lord. Here, my lord, your lordship will find running charge without GST. He has quoted 28.94.
Ah.
Now, if your lordship see, page 340, this bid is to be opened next day,
itu কোন তারিখ কি মনে?
27/9/23. Same tanker, water tanker.
How much was 28 point, no, but the rate is 89 point something.
No, that is correct, my lord. Considering that 2.75 into so and so.
290.
That is why, well, here, he has quoted.
No, but then here, no, he
28.9.
is not agitating that issue.
No, that is, my lord, because he knows what is the rate. Now here, what he has said. Your lordship see. Here, that is correct, my lord. Same thing.
My lord, kindly come to page 437. 437. In fact, just now we have seen 4 different rates in 4 different
No,
rates.
no, tell me one thing. Were there different rates for
Yes.
Sipsagar today? End of the matter.
My lord, will kindly come to page 437.
Yes.
My lord, we filed this affidavit on 13/5/24. This
Wait.
affidavit.
Ah.
Kindly see, my lord, Astha Energy 97.22.
Nine,
top rate.
Asta Energy. Yes, center, yes, 97.20.
Then my lord will kindly come to next one, Damani, same rate.
Favorite,
Then kindly come to serial 3, Relimec
96.
0.89. Then my lord, Lohit Fuel Service 96.88. The not prices are uniform. So which price they will take? Because I can't quote less than that. On that day, I quoted the rate I got from Google. It so turned out that somebody gave a rate of 96.17.
So what is what is to be done? So there's to be a fresh tender? or what?
Yes. In
And,
respect of the ones which are not
and
given.
but how do we know the rate of the diesel on that thing? If Shivsagar is giving 3-4 different rates, what is the
Actually,
solution?
the practice is, my lord, every morning there is an SMS comes from the oil company to the dealer. This is the rate, and that is the rate they charge
My lord,
every morning.
that depends on, my lord, the distance, my lord.
Whatever it is,
Dealer, suppose the dealer is in city, my lord. You will get that. It's like a distant place, then the rate will be calculated.
No,
I have
that-
seen, my lord, the Guwahati that I found, 8-9, my lord, depots same. Today. Because here that net is very poor, so only I got the,
So in Guwahati also it will be different rates?
yes.
no, my lord, same rate, my lord, I'm showing, my lord. It is.
No, even now, Google, I can go and get the rate of Sipsagar.
Here,
So what is the rate?
Yes,
my lord,
I'll show. Just
distance they have shown, Borwa service station, 97.14 petrol, my lord. Lakshmi service station, that 97.14, distance is 1.2 kilometer. Chanmal Saragi, 97.14, same. Thanmal, 97.14, distance is 1.7 kilometer. There,
today, my lord,
My lord.
Sipsagar rate is 19.42.
And the one you saw?
So, my lord, all the problem will be solved because basic price is given in the tender as you did it earlier. I have shown 2 tenders. That's why, my lord, these people are conscious of the fact. Since we are insisting on a condition whether this is available in public domain. Now I go to one petrol pump rate, I quote based on that. Somebody will quote a lesser price because their price is less.
I got at least 15 people, my lord, same price.
Same. So then it belies your argument that rates will be different depending upon the distance.
Distance, yes, my lord. Distance, my lord, city, from outside.
Then no, then the rate should have been different.
No, that it is within city, my lord. What I got in my lord, the come up with,
Okay, okay. So using that, if you use the same yardstick, within Guwahati is the same. Now within Sibsagar it's different. Then it will be districts or what?
Since city is same, if it is slightly outside, then the freight will
But what about Sibsagar? So
out of the outside, my lord.
how do you know?
Yes, my lord.
No, Sibsagar is a small town.
That is outside, my lord. That is why, my lord, the freight is added. Yes. That's a district, my lord. You also see the kilometer has been given.
No, anyway, the issue was that it was all.
Whether that is available in public domain.
It is available in public
But in a
domain,
different form, distorted
but giving different rates. So and you all are going to decide the matter, they're going to decide the matter or based on one rate.
Yes.
It will be on one rate, correct. Now, which rate is the correct rate? That's all.
As a tenderer, we don't know. So therefore, the best practice would
they
be
knew
to
it
give
very
a
much.
rate as they did earlier.
They knew it very much from the two, there are two submission of tenders, my lord, I can show that.
They knew very much, but then what to do? This is a argument that they have raised and it is a justifiable argument.
An argument, my lord, that is what I am submitting, that's a, this institutional filed affidavit actually. My lord, because he himself filed, 2 tenders. One is opening today, another is next day, my lord. Only 2 days, 1 day. And.
But then petrol prices or diesel prices don't remain the same every day.
No, those 2 days same, my lord. 2 days same.
2 days are same.
Yes, both the days are same. Because
He said those 2 days.
Those 2 days, per se. Because the 2 places I have shown, my lord, you'll also 282 and 340. From there, my lord, you'll also find that he had filed this reiteration.
Okay, right. Heard Mr. K. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. L.N. Dihinge. Also heard Mr. G.N. Sahewala, learned senior counsel for the respondents number 2 and 3, assisted by Mr.
NAC.
Huh?
NAC.
NAC. Mr. Chaudhary is not there. You're not there. Okay, you're there.
For the purpose of.
For the Mr. M.K. Chaudhary, learned senior counsel appears for the respondents number 3 and 4. 4. Assisted by Mr. T. Bhardwaj. Anybody there? Anyone for 1? TGC. Mr. S.S. Roy appears for respondent number 1. Where is this clause C2 page?
177.
The petitioner has prayed for setting aside clause C.2 of the NIT. Bearing e-tender number R16 KC 23 003. Wherein it has been given in the fourth paragraph as follows. Bidder to note that quoted basic running rates per km exclusive of applicable GST should not be less than 0.275 into diesel rates declared by IOC for Sibsagar as on TBO date. TBO means? TBO date, huh? Page 177 it is there. What is this? To consider dispose of representation complete. This is the.
Prayer, my lord.
Ah,
Earlier, there were representations were there.
so that's not relevant now.
That's not, basically not.
Okay, right. The basic case of the petitioner is that the diesel rates, the basic case of the petitioner is that the IOCL have not declared a standard rate for the high-speed diesel for Sibsagar on their official basis and on a daily basis. He submits. Next paragraph, the petitions council submits that the diesel prices declared by various diesel outlets in Sibsagar district is different, and as such, clause C.2 of the NIT is unworkable. That's your case. Nice. Mr. G. N. Sahavala, the learned, SN G. N. Sahavala, the learned senior counsel for the private respondent, on the other hand, submit that the IOCL declares a standard rate each day for the high-speed diesel in Sibsagar district. And this can be seen from the official website of the IOCL. Mr. M. K. Chowdhury, the learned senior counsel for the IOCL, also submits that as per the official website of the IOCL. Where is it? Your affidavit? Ah. Affidavit. Yeah. Okay. Mr. M. K. Chowdhury, the learned senior counsel for the IOCL, submits that one. No, where are you reading? Which? Oh, oh, wait. Oh, wait, 415. Pagination is different.
Annexure P6. Last page.
415. Oh, okay, submits that, yes, yes. Okay, submits that Indian Oil provides one mobile app showing the rates of MS and HSD for retail outlets across the country. Thus, rates of MS and HSD for Sibsagar district retail outlets can also be viewed in the app. Huh. So further, there are other ways to get the pricing of MS and HSD at any retail outlet in the country. First off, any person can get the RSP. What is RSP? Retail sales price, bracket RSP, by sending an SMS with the with the text as below, bracket with the dealer SAP code of a particular petrol pump, bracket close, RSP, and you just think, it is at page 415. I'll put it in blue, that line, small one line. Any you have filed the affidavit also? This is the affidavit. So the IOCL rate will be one rate per day per district. That you found now, but then according to we can record your statement that it appears that there is some variation. Is it? No, you tell me. I'm going to record. I'm not going to record. You see, you cannot say something and then not want it recorded. Huh. So he, however, admits to the fact that on application of the app being used in the presence of all the parties herein, there was minor variation in the prices of the HSD in the various petrol pumps, in the various retail outlets in Sibsagar. First. Next, I have heard the counsels for the parties. I think this order passed earlier will do. 4/10/2023, है ना? 4/10/2023, para 2, para 3. Para 2 and para 3, okay. Pusta. To ascertain whether the IOC declared their HSD rates for Sibsagar district in the public domain on their official website, the IOC had been directed to submit a report with regard to the same. As can be seen from the submission made by Mr. M.K. Chowdhury, the senior counsel for the IOC, and the affidavit submitted by them, page 437, no? 415. 415. The stand of the IOCL was that the standard rate of the IOCL, of the HSD in Sibsagar could be ascertained if one went into the Indian Oil One mobile app for retail outlets for Sibsagar district. This court had requested all the councils to use their mobiles to find out the standard rate for HSD for Sibsagar district by using the Indian Oil One mobile app. The mobile of Mr. P. Bhardwaj had been used, and it was found that there were variations in the rates of the, no, sit down, sir, in the variations in the rates of the HSD for the various retail outlets in Sibsagar. Full stop. Slight, huge, is the variations anyway. Doesn't make it. You see that, because the clause C2 requires one standard rate. So there's a variation of minus 0.0000 million times one, also there's still a variation, doesn't matter. What have I said? First of all. Which would, in effect, make the, which would make the clause 3.2 of the NIT unworkable. In view of the reasons stated above, the disqualification of the petitioner's tender documents, correct? Disqualification, technical bid. Was not proper, and as such, in the view of this court, a fresh tender notice would have to be issued for the Sibsagar district.
My lord, they will stick to their earlier practice.
For the Sibsagar district. Full stop. I do not know. Let them find out a method.
Hello.
I will not say what is to be
My
done.
lord,
Sibsagar
okay.
district. Full stop. Accordingly, the IOCL shall issue a fresh tender notice. ONGC shall issue a fresh tender notice. And by making it possible for all the tenderers to incorporating in their tender notice a method to enable the tenderers to get to know the standard rate of the HSD for Sibsagar on for each day. The writ petitions accordingly allowed. Suppose of
Lordship, in this matter, I am seeking some accommodation, Lordship, due to the elevation of the learned counsel on record, Lordship.
item
17,
matter pertains to
matter pertains to dismissal of the delinquent, Your Lordship.
is not here anyway.
Lordship, yes, we are trying to establish contact with the management, Lordship, but the phone number we are not reaching.
Okay,
So
right.
we have sent an email.
Yeah, for the petitioner? No. No one appears for the petitioner on call. Accordingly, release this matter after the vacation.
Lordship. Thanks, madam.
Should I record your presence?
Lordship, because I am not on record.
Definitely. No one appears for the petitioner. This is the matter after the vacation. Yes. This case was earlier dismissed. Or what?
No, it's continuing.
Huh?
It's continuing.
There is, what is this order that is here? Acha, this is some, okay, this is it. Okay, this is different. Okay, yes.
This case, you will, please to turn to page 26 of the petition. So, initiate one.
Page 26 is the
Initiate one.
tender notice.
Yes.
There is no date. Correct?
No. It leads to tender for road transportation of bulk petroleum products. AFT, ATF, that is air turbine fuel,
Air turbine fuel.
by top loading tank trucks under IO Assam Oil Division State Office. Locations have been given, Guwahati RCO, Bangladesh RCO, Lumding Terminal and Misapuri. The work. I'm a petitioner, I was an existing supplier of tanker truck. These are basically tanker trucks, but specifically made for air turbine fuel.
What trucks?
Air turbine fuel, tanker trucks.
Tanker trucks.
At page 30, you also will see the
Page
30.
30.
These are publishing the tender document was 25/6/2023.
Huh?
25th June
Yes.
2023.
23/7/2022. Is there a stay order in this case?
No, no.
No. So this for transportation, this period is how, from which period to which period?
5 years.
5 years. Okay. So you were unsuccessful.
I was regular supplier, but I was discontinued.
Why?
By virtue of the
Rate was higher.
no, because of the settlement given to the private respondents.
Why was settlement? It was on the basis of a tender.
Tender.
So in the tender, why were you overlooked? Your rate was higher than them.
No, that is not true.
Then what is the case?
It was a case of manipulation, your lordship. That is my submission.
Okay, your submission is manipulation. Manipulation meaning what? Manipulation can mean a lot of things. Documents. Fake documents.
Fake documents.
Submission of fake documents.
In violation of the law. Motor Vehicles Act. Motor vehicle rules.
So they have been given the work due to fake documents. Which are the fake documents that you are talking about?
The license, the permits
License for what?
for the truck,
License for the trucks.
driving license.
Huh?
Driving registration,
License for the trucks.
registration.
Registration for the truck. Registration. And what else? That's all.
And violation of Petroleum Act and rules.
So they must be having permits from the
Permits, all
permits are in
violation
violation of the
of the Act and rules.
of which act and rules? Explosive Substances Act and rules or what?
Yes, Explosive Motor Vehicles Act and the Petroleum Act.
MV Act, Explosive Substances Act,
Petroleum Act, which
and Petroleum Act.
Act and the rules.
Act and rules. Now show me which documents, which. You have to give me.
Sociable, look in page 31 first.
31.
Pre-qualification criteria.
Pre-qualification, yes.
First of all, the minimum number of tank trucks to be offered,
Ah,
all owned.
3.
Minimum 3 in case of general and general MSC tenders, and minimum 2 numbers
And are you general or SC/ST?
general.
General. So 3.
Tenderers can participate with eligibility. Lordship is important. Tenderers can participate with ready-built tank trucks as well as with purchase invoice of the chassis. SC, ST and ST, MSC tenders can also participate with booking slip of chassis. They have given an age and model of the tank trucks. Age and model of tank trucks as reckoned from the date of manufacture in RTO registration. Offered should necessarily be below 15 years or higher models as on the closing date of the tender. Then valid RTO registration and PISO license for ready tank trucks. Clause number 10 at page 32.
32.
All ready built tank trucks offered should have valid RTO registration and PSO license. All TTs offered against purchase invoice should necessarily have chassis number mentioned in the invoice. Tenderers offering TTs against purchase invoice booking slips should submit separate purchase invoice booking slip for each of the tank trucks offered. Capacity against the purchase invoice booking slip shall be clearly mentioned by tender. The eligibility criteria at next page 33, clause 4. All offered tank trucks should have valid RTO registration and CCOE license. I will take a look into the evaluation of tenders. I'll come straight to the point of violation of the to economic property. You will submit. A tank truck is not readily available
Tanker truck is not readily available. Okay.
in a built up manner. The tank truck is required to be assembled in various stages at various locations. Firstly, the chassis along with the cabin, known as cab chassis, is to be purchased from the authorized dealer. At the time of purchase of cab chassis, 4 number of documents are provided, namely sale letter, roadworthiness certificate issued by the manufacturer, invoice of the dealer, and insurance certificate. Thereafter, the purchaser is required to obtain temporary registration certificate. It's mandatory from the concerned office of the district transport officer.
Okay, one thing before we go into the merits. This is the second time before this court?
Second time, same case.
No, no,
And it came up.
same case.
It came up.
There was a earlier writ petition. Huh?
Earlier, in the question. No?
Was there an earlier writ petition?
That is different.
No, no. In that earlier writ petition, what was the challenge made?
It was challenged to the rate
Challenge to the rate.
of the tender.
So at that time, in the earlier writ petition, has the contract been awarded to the?
No, it is
No.
pre-tender.
Okay, then it's, I was just thinking constructive res judicata or something. Instead. So that is not there.
This is after the award of the contract.
And the other one was prior to the award. How long will it take?
Okay.
I just want to know. I'm willing to hear. It's not that I'm not willing to hear. But I want to know because 4:30 I've got a meeting. I've got to rise at 4:30. So I want to know if you can finish within time. I don't know how long will it take, and then how long will it take?
Not possible within. It'll take about hour and a half.
Oh my God. Then there's no chance.
No chance.
I thought if you can finish in another 15 minutes, then they can do it another 15, 20 minutes, then I can. If you're going to take 1 hour, then there's no chance to do it.
And all of us have raised the maintainability issue, my lord. So all of us will be arguing on merits. That's why,
Maintainability can be taken up before taking up the merit.
my lord, even though me being the council of ILC shall not go into the aspect of constructive adjudicator, but my learned friends will.
Why should you go into constructive adjudicator? How can you go into the constructive adjudicator? Because was this because it's different.
Constructive adjudicator is also there, and again, concealing that fact that they have raised, they have challenged the causes of the tender in an earlier round of litigation, and also the petition was dismissed by the division bench after being dismissed by the single judge. That
Okay.
has been concealed. We have got those things into record.
We managed the prayer of that case of in our petition.
They're seeking for a inquiry based on another petition that was pending for the
Which is, which as on date stands dismissed with a cost of 50,000.
that is the order, my lord, for that, my lord.
Acha, directly they have to set aside and pour the letter.
That was different case, not us.
Your prayer is to have a CID inquiry. CBI.
If I may just point out a single thing, Your Honor, nowhere in their petition, specifically their prayer, they have challenged our licenses. As of date, our licenses stand. If we go by 114 of the evidence act, when official act done, is considered to be evidence. Furthermore, since they have not challenged that particular licenses, they are just coming outright and saying that they should, the lordship should dismiss, set aside our award, letter of acceptance. And on the aspect of CBI inquiry, the courts in Sakari Vasu and various other judgments have gone into to say that this read court should not outright give an agency to investigate a matter unless and until it's of national or international significance or is very much required by this court to investigate, go into investigation. In Sakari Vasu, they have outright said that even if the defense person who was a whistleblower was murdered and the police was investigating, there is a proper procedure. Police, then the magistrate, then other agencies have to go into that. So that way also this rate petition.
Only problem is now he's not going to finish for some
Yes,
time.
sir.
And I don't have time till after 4:30. I was set for.
Let this be taken up on a hearing day after vacation.
We'll fix it after vacation. Right. No, no partner, no partner. No, there's nothing partnered on it. Right. On the prayer, the parties is the matter after the vacation. You select a date. Which date do you want?
23rd of July.
23rd July. Okay. Finish.